Can I just say something about Andrea?
Hey everybody, welcome back. We are just waiting for court to get started over in Provo, Utah in the motion to disqualify the Utah County Attorney's Office that Tyler Robinson has filed. If you've followed me on any other platforms, you probably know I have some questions about how much of this we're even going to be able to see. I guess we'll just sit and find out. We'll talk about a little bit about that in a couple of minutes as we just go through what is on the docket for today and what they're addressing. But you also probably remember from last time that there was a little bit of a rebuke from the court about the operation of the cameras. The defense had moved to remove the cameras at that point because, you know, for like first hearing live with Tyler Robinson in the courtroom, and they already violated the decorum order. This is like shades of Koberger all over again. But one of the advisements was that the order very specifically said that they are not supposed to start the cameras, not supposed to start recording until court is in session. And this kind of became an issue because many of you may have seen that in the downtime before court was getting started, the cameras were focused on Tyler Robinson and his defense team. They're having some, you know, kind of just muffled conversation. And there were some really, really bad, really ridiculous purported lip readings of this conversation that, I mean, it's, you know, sometimes I just wonder how people put stuff out with a straight face when it's just so obviously ridiculous, and like you can see with your own eyes, like the lips are moving and they are not saying the things that this text is telling you that they're saying. So anyway, all of that was a bit ridiculous, but it was also, again, problematic because another one of these limitations in the order relating to the cameras was that it's not supposed to focus on conversations between the defense and his team, particularly in a way that would permit lip reading. So like exactly the thing that the judge had sort of foretold was at risk to happen did in fact happen. So anyway, because of this, we're on a little bit of a hair trigger waiting for court to get started because it's probably going to just like start like that. So hopefully we don't miss anything. If we do, we'll just, you know, be a little behind, be a minute behind or something like that. But gonna do our best to catch that as it goes live. So the reason why I'm a little skeptical about what's going to happen today is based on what has evolved over the course of the last couple of weeks with this motion. And so we went through this motion at the last hearing. It is filed. There's been a lot out about it right now. The basic gist of it is that there is a relative of an undisclosed member of the Utah County Attorney's Office who was present at the shooting, and during the shooting was sending like live updates on a family group text, a group chat, about, you know, kind of what was going on and what they were learning and so forth. This deputy prosecutor was then one of the ones who responded the day of the incident. Like they, you know, kind of set up a command post sort of situation for the investigation. And so he was heavily involved in that investigation from quite early on in the process. So the defense has argued that this person is a potential witness. This relative is a potential witness, and that creates a disqualifying conflict of interest that they think needs to be imputed to the entire prosecuting attorney's office, largely because of the supervisory role that this particular deputy prosecutor has. So we know it's not Jeff Gray. We know it's not the elected, just from how the motion is written. But otherwise, they are going to great lengths to conceal who exactly it is we're talking about, which prosecutor, what relative, and so forth. So because of that, all of these documents have been filed, you know, under redaction. So that's the basic gist of the motion. I'm not going to get real in depth into it because we have looked at it before. But so then what happened was the state filed their response, and they have basically said it's not a problem because there's nothing unique about this witness. This is not a material witness. They're not even like a particularly good percipient witness because they weren't looking. They weren't in a good position to be able to see the shot, to see Tyler Robinson, like the shooter would have been, assuming Tyler Robinson is the shooter, to see the shooter on the roof would have been out of their range of vision and so forth. They argue that this particular witness wasn't especially traumatized by this event, certainly not relative to other folks who witnessed it that they talked to. So there's nothing that's like, according to them, a sort of personal vendetta or just protective, urge to look after this relative that would particularly affect this prosecutor. And then lastly, they went into some of the process about their decision to file the notice of the death penalty, which the defense had argued, hey, it's possible that the emotional reaction to this, because there was a relative involved, played a role in that decision to seek the death penalty very early. They've said, no, it doesn't. So we will go through this in just a little bit more detail. So first off, this is going to be important. They make some factual assertions from the county attorney, Jeff Gray, and from the deputy prosecutor that's at issue, but they haven't filed affidavits, and they haven't, otherwise kind of offered sworn testimony. And so they've anticipated, well, they may offer testimony on this matter, if for whatever reason, they're just asserting it here in this motion is not going to be good enough. Now, for practical purposes, this is a death penalty case. All the I's have to be dotted. All the T's have to be crossed. Them just saying so in a motion, unsworn, it's not going to be good enough. It's not. It's just not. You have to do things properly. And a prosecutor's arguments in a brief are just that. They're just arguments. They're just assertions. They are not things that the court's able to rely on to find facts. And they're going to have to find facts in this situation in order to evaluate if this is a disqualifiable conflict or not. So there isn't really going to be a way of getting around. They need testimony on this. Now, the form of it is questionable, I think. Do we need to have a full hearing with testimony and cross-examination and all that, or would it be enough to submit affidavits? That's a little bit more of an, of an open question. But at least at this point, like this footnote, no, this is definitely not going to be enough. There's going to need to be some kind of testimony. But be that as it may, the basic facts that they're asserting was that, we know the setup of the event that Turning Point USA was having at UVU and where Charlie Kirk was situated and so forth. There were about 3,000 people there. So it was a child. We know this was a child, the initials AC of the deputy attorney, an adult child, but barely. And so that person was present, standing on the far right side of the amphitheater as you look down from the top, 85 feet from where Charlie Kirk was seated. This is looker's right. If you I said that wrong. This is skier's right. Like you have skier's right and you have looker's right. If you yourself are the skier going down the hill, you have a right hand and a left hand. But if you're the looker looking up at the skier coming down at the hill, it gets reversed, right? So this is skier's right, as I understand it. You're looking at where Charlie Kirk is. It's over on your right-hand side if Charlie Kirk is in front of you at 12 o'clock. There was no line of sight between AC from AC's position in the amphitheater and the shooter from his position on the Losi Center's roof because the Sorensen Center stood between them, and AC would have had to move 75 feet to the southeast before establishing a line of sight with the shooter. Charlie Kirk was shot. AC did not see Charlie Kirk getting shot because AC had turned and was looking at the audience and then heard the pop and heard someone yell, "He's been shot." When everyone realized there had been a shooting, attendees crouched down and people started running away. AC did the same thing, ran into a building behind AC, went through the doors just to the northwest, never looked back at Charlie Kirk, and thus did not see him get carried away or see his wound, didn't see anyone in the crowd or elsewhere with a gun, didn't see anything that made AC believe anyone anyone AC saw was involved in the shooting. So nothing that was like, ooh, maybe she or he or whatever saw Tyler or any other shooter or anything like that. Even after running into the building, AC did not know what really happened. AC heard that someone had been shot. So at 12:25, AC sent 2 text messages to AC's family about the shooting on AC's family chat group, which included AC's parents, siblings, and their spouses. Those 2 text messages to AC's family read, "Someone got shot, and I'm okay. Everyone is going inside." After someone in the building told AC that Charlie Kirk had been shot, AC sent a 3rd text message to AC's family. "Charlie got shot." Screenshots of those text messages are attached. So they submitted this, at least this section of the family group chat, in support of the motion or the opposition. When Charlie Kirk was shot, Deputy Attorney was with County Attorney Jeff Gray at a conference in Ogden. Deputy Attorney first learned of the shooting when he read AC's text that Charlie got shot, and he shared that text message with Gray. Deputy Attorney left the conference 10 to 15 minutes later and drove to the law enforcement command post that had been set up at UVU. Gray did the same about 20 minutes later. What is more, as in other murder cases, other county deputy attorneys would be making their way to the UVU command post. Over the next 2.5 days, Deputy County Attorneys Ryan McBride and David Sturgill spent most of their days and some nights at the command post, assisting with search warrants and providing other legal counsel. So basically, got this group text, kind of knew that the relative had been there, that this thing was going down, and seemingly was like maybe one of the first prosecutors on the scene at the command post, helping with the legal aspects of the investigation. Might it have been preferable for somebody else to take that role? Perhaps. Now, is it going to rise to a disqualifiable conflict of interest? Is a much closer question. But in a you have the option to do things differently and just, not have this complication come up, but you didn't. And so here we are. Although AC was scared at the time, AC has not had any lasting trauma from the event and has been able to continue with all of AC's normal activities without any emotional problems. AC has not needed counseling or therapy. AC has not missed classes. AC has not missed work, and AC has not missed any other normal activities. Gray's decision to file a death penalty notice on the same day he filed the information had nothing to do with AC's presence at the TPUSA event. He filed the notice immediately because, 1, Gray determined that the evidence of aggravated murder is substantial. 2, Gray ran for elected office almost 3 years earlier on a commitment to seek the death penalty in appropriate cases. 3, Gray learned in State v. Jayne, a pending aggravated murder case, that waiting to file notice when the evidence is substantial only fuels speculation and misinformation. And 4, Gray wanted to minimize the speculation and misinformation in this case. So this is their basic factual assertion. Their description of what happened and why, in their view, it's not really a big deal. It didn't really have any kind of effect on how they conducted the investigation or made any kinds of prosecutorial decisions. And so it doesn't warrant the relief that the defense is asking for. So they are essentially arguing he's got no conflict of interest because the child is neither a material witness nor a victim in the case. In fact, nearly everything AC knows about the actual homicide is hearsay. Heard it from other people. He had to be told Charlie was shot and so forth. And because Mr. Deputy Attorney has no conflict of interest, the county attorney's office also has no conflict of interest requiring disqualification. Second, even if Mr. Deputy Attorney were to have a conflict of interest, the nature of his conflict is unlike those cases requiring screening, where a prosecutor may be privy to a defendant's communications and trial strategies. And we talked about this before when we looked at the motion itself, like what the standard is for disqualification. There has to be a significant risk that the prosecutor's ability to represent his client is going to be meaningfully limited by his duties to another client or his some kind of personal interest in the case. So it's not just a flat out, any connection with the case means you're out. It's got these qualifiers to it, a significant risk and a material limitation. So they're essentially saying, look, the risk is not high because this person is unlikely to be a witness in the first place. And the concern in the situation when you have a family member involved in something like this is like, well, what if the defense calls this person as a witness and puts him on the stand, and now you have to prosecute, you have to cross-examine your own child. You're not going to do a good job at that. So you have to look at that risk, and then how substantial is it? Well, arguably, it's not really that substantial. If the witness has nothing material to add, then they're probably not going to be a witness in the first place. But even if they were, can you avoid that risk by just having one of the other prosecutors do that cross-examination if it were to come up? Like, is this such a big deal that like no prosecutor would be able to cross-examine this witness? Little bit more debatable, that one. So not necessarily clear, that on its face it's going to meet that particular standard. Then as far as the examples they're giving here, this is what we looked at last time, where times when a whole prosecutor's office gets conflicted out, these are typically limited to situations where the prosecutor was formerly the defense attorney on the case. Like, that part is really crystal clear. If you were representing somebody, you had confidential communications with them, you have a duty of loyalty to them, which continues beyond the end of the representation. You learned about their strategies, you talk to them about their case, you know what the evidence is, you know what the approach is going to be. You don't get to now change sides and go sit at the other table, because it's pretty much impossible that you wouldn't use that information against them in some way. Certainly you wouldn't be able to be a good prosecutor if you weren't using everything you knew to be able to prosecute them to the best of your ability. But because of your previous position, you had access to information that you're not entitled to as a prosecutor. And so being able to segregate that, not realistic. I went through, when this motion was first filed, I went through and read a bunch of stuff about prosecutor conflicts. And I found this law review article that it talked a lot about why this is kind of a difficult issue. It doesn't get brought up really all that frequently because prosecutors, like judges, are kind of assumed to be the front line for deciding if they need to recuse themselves in the first place. And so they kind of evaluate their own conflicts and decide for themselves if they think it's a big deal or not. And so a lot of times that's just where it ends. If the prosecutor decides, I think it's fine, this person is my neighbor, maybe, but we don't necessarily know each other very well, so I don't think it's a big deal for me to prosecute them, then that might be the end of the story. So the only time it really comes up is when there is a request to disqualify the prosecutor. And that requires, of course, a lot of things to happen. It requires the knowledge of the relationship to be disclosed or to become known. It requires the defense to, kind of want to pursue that, not just like get a quick plea deal and be on your way and so forth. And then, you have to go through the process of litigating it and then convincing a judge that this prosecutor doesn't belong on the case. And that can be a particularly tough call in the case of a prosecutor, much more so than a defense attorney, maybe surprisingly. But the reason why is because it implicates some separation of powers issues. The prosecutor is considered, an executive type of official. It's an arm of the executive branch of government, law enforcement, and in prosecution. And so they have been the chosen representatives of the people to conduct these types of activities on their behalf. And so to interfere with that is kind of a big deal. And so that's why courts have typically required, there's got to be a pretty strong showing, a pretty serious type of conflict to warrant interfering with that decision and getting rid of the people's elected representative. And so because of that, the types of conflicts that disqualify prosecutors tend to be pretty minimal, and certainly compared to the universe of things that could potentially interfere with your ability to, make good judgment calls on behalf of the public about what you're doing with your cases, how you're pursuing them, and so forth, the kinds of penalties that you're looking for. There's a lot of things that can get in the way. Just your personal viewpoints can get in the way. There's this kind of idea that, we recognize close relationships, close personal relationships, close friendships, certainly like business relationships and financial relationships and stuff like that are obviously going to affect people. But there's this sense that at a certain point it becomes remote. And so the whole friend of a friend kind of situation, they will give a lot of deference to the prosecutor's own opinion, that they can put that aside or it wouldn't affect them. But it's reasonable to question that. I mean, the prosecutor operates in a political system. Typically, prosecutors are elected. There's just dynamics involved, and old boys clubs and things like that. And so one of the areas where this has come out real recently as a topic of just significant focus is when prosecutors have to investigate or prosecute law enforcement crimes, like particularly officer involved shootings and things like that in their own jurisdictions, because these are the same people that they work with all the time, routinely. And now they're kind of expecting to put on this hat of, we don't have one of these formal relationships that's recognized in the case law for a qualification. It's not a family member. It's not somebody that we have a financial tie with, but it is somebody that you work with routinely. You're going to have preconceptions about them and their performance and their value and all of these types of things that you just cannot imagine aren't going to color their judgment of a situation like that. And so this is kind of creating a little bit of a stir in this area, because sometimes prosecutors will recuse themselves, and that's, I think, the smart thing to do. But what if they don't? What if they don't? Is there really any mechanism? Are courts going to say? Are they going to reach the point of saying that this is the type of conflict that should disqualify them? There's really not a lot in the case law so far that would support a ruling like that. So, kind of have to be developed and be new. So I wanted to just kind of talk about this a little bit broadly, because, when it comes to conflicts of interest, it's not really that easy of a situation to deal with a lot of the time, because the rule isn't black and white. It isn't you have any connection with the case, therefore you're out. It's understood, and particularly this comes up so much. This comes up so much in smaller communities than it does in big urban jurisdictions where you have all kinds of personnel, and it's not really a big deal to just, take this prosecutor off, shield him and put another one on. When your entire prosecutor's office is maybe, 5-10 people, it gets a little bit more complicated. And so in those situations, they play much more in this gray area of, is the risk substantial, and is the potential limitation really material? than they necessarily have to do in big cities where they can just, just err on the side of we don't need the headache and go ahead and reassign it. So ultimately, that's what they're saying. Look, we weren't the defense lawyer on the case. We don't have any kind of inside information. We're dealing solely with a relationship. And so given that, we have to consider, what is the likelihood that this relationship tainted the entire office? And what is the likelihood that that relationship is going to limit their ability to be good prosecutors at all? So I want to go through this again, not like in super great detail at this point. All of these documents, by the way, as I'm sure many of you know, they are up on my Substack on the legal document page. So you can go and find those. It's free. You don't have to pay to subscribe or anything. And look through them at your convenience if you want. So they are just basically kind of spelling out in detail what the factual allegations are. The one I wanted to get to, this is all just stuff about the relationship with the family. But the death penalty notice, he got into a little bit more detail about what happened in this other case, the State versus Jayne case. It was less than 5 months after filing the information when they filed the death penalty notice in that case. It was 6 weeks before the court first set a preliminary hearing. Less than 1 month before the charges and death penalty notice were filed in this particular case, in Tyler Robinson's case, the Box Elder County attorney filed a death penalty notice on the same day aggravated murder charges were filed in State versus Bate. So it's another situation where filed the information, filed the death penalty notice the same day. There was not a delay in deciding whether they were going to pursue the death penalty. So it's not like it's unprecedented. Other prosecutors have done the same over the years. In this case, they did it immediately as the result of lessons learned in State versus Jayne. As in this case, the Utah County attorney concluded from the outset that he would seek the death penalty in Jayne, but choosing to follow the convention of some, the county attorney initially opted to wait until after the preliminary hearing to file a death penalty notice. But a few months later, this delay spawned rumors that the county attorney would not seek the death penalty. A member of the press then contacted the office indicating that he intended to air a story that evening that a source had told him that the county attorney was not seeking the death penalty. The county attorney immediately contacted the reporter, informing him that the report was not accurate and thereby averted the airing of a false report. Anonymous sources close to the investigation, close to the prosecution. Where have we heard that before? Speculation and misinformation in aggravated murder cases are extremely unsettling and hurtful to the families and loved ones of murder victims. They make every effort to minimize that hardship. So in this case, it's already generated a tremendous amount of speculation and misinformation that has been apparent from the moment Charlie Kirk was assassinated. Having reviewed the evidence and concluded that the evidence and circumstances of the case justify the death penalty, the county attorney determined that there was no reason to delay making that election. Filing delay would only result in further misinformation, speculation, and conspiracy theories, which were already mounting before charges were even filed. The county attorney has concluded that under the circumstances of this case, delaying the filing of a death penalty notice is unnecessarily unsettling and painful to Charlie Kirk's loved ones and does not promote justice for anyone. For these reasons, the county attorney chose to file a notice of intent to seek the death penalty on the same day charges were filed. So that's their explanation. Nothing to do with the deputy prosecutor's relative. It was because they had this previous situation where the delay in filing the death penalty notice led people to think they're not going to pursue the death penalty at all. Somebody was able to scrounge up an anonymous source to say, yeah, I know for sure they're not going to pursue the death penalty. That was going to be aired. That was going to cause, chaos, misunderstanding, and so forth. So rather than go through that again, they elected to pursue the death penalty right away. Now, they submitted, here's the group chat like segment that they submitted in support. And they also provided an affidavit of AC, who is the child of the deputy deputy prosecutor. And so describes attending class before the event and arriving at the courtyard at about 11:15, watching from the right side of the amphitheater, and just basically going through the account that we already saw marked on the map here, kind of where things were located. So this is skiers right, lookers left, right? That's where the individual was located. Charlie Kirk is, of course, right here. And the shooter is going to be, I don't know, somewhere, I think over here, somewhere over in this area. So, again, copies of the group chat. And then they have these additional declarations from an investigator with the Utah County Attorney's Office about getting this information, going out. Looks like we're getting started. No, they're just doing ads. Investigator goes out with the deputy county attorney to basically take measurements of the scene and be able to, evaluate the lines of sight and come up with this 85 feet away, and wouldn't have been able to see where the shooter was located and so forth. So that's their evidentiary basis. So far, so good, kinda, more or less. But then we get to the reply, and the reply takes serious issue with this process of developing the factual record. The reply is basically saying, we've already accused you of a conflict, and now you're involving yourself in the investigation of the conflict. And so you're conflicted in your factual development here because you're the ones who chose what parts of the story were included in the affidavit of the witness, what parts of the group text were included, what the investigator from your office was going to go out to the scene and look at, and so forth. And so because of that, we need an opportunity to be able to probe some of these assertions, this thought process. Like, we don't have to just take what the prosecutor says on faith. We're entitled to ask some hard questions about that. And so they plan to have an evidentiary hearing. We already kind of know that. So they have subpoenaed, I guess, four witnesses that they've talked about. There's a public subpoena for a sergeant. The heck is his name? Sergeant Gray, I think his name was. Sergeant David Hull. He's the only one that is named, that there's a public record of him being subpoenaed for this. Presumably they want the deputy prosecutor and probably Jeff Gray to talk as well, since they hadn't submitted sworn testimony before, and their explanations are part of this. And this kind of sums it up. Really, without an evidentiary hearing, the defense is limited to the facts the current prosecution team unilaterally chose to disclose. So, it's a fair point. I think it's a fair point that they have just as much right to develop the factual record as the prosecution does. Now, that says you're kind of implicitly calling the prosecution, misleading, maybe lying, maybe hiding something. You're calling them shady. This is probably not going to be great for like the long-term collegiality between these parties. Because this is they're suggesting we want to cross-examine the prosecuting attorney, and that's not a real comfortable place for that prosecuting attorney to be. But the reason why this is calling into question for me what we're actually going to be able to see here is because they've gone to such lengths to keep all of this confidential, the identities of the people confidential. And so it's kind of hard to imagine how they're going to be able to, have people testify, put them on the stand, in full view of the public. You don't have to have the cameras on them, but you can't really close the courtroom door unless they do, unless they decide to do all of this basically hush hush. So, looks like they are getting started. So let me go ahead and get us over to there. And here we go. Do we not have sound?
Novak, Michael Burt,
There we
Stacy
go.
Visser here on behalf of Mr. Robinson.
Good afternoon. Good afternoon to you, counsel. Mr. Robinson, good afternoon as well. All right. Before we turn to the defense's motion, the court would like to address 4 preliminary matters. First, in regards to the transcript from the December 11th hearing. Counsel, I would appreciate your input regarding the transcript from the December hearing. The transcript has been designated as private and copies are available to the parties. Consistent with the court's prior handling of the October 24th transcript, the court intends to release a redacted version of that transcript, but I want to get your input before making a decision.
This was the whole matrix problem,
Judge,
you know.
We intended to do that as well. We haven't stipulated, we haven't come together to stipulate on a version of that transcript that should be redacted. We certainly can do that, and we're happy to do that.
Thank you, Mr. McBride.
We will meet and confer with Mr. McBride and his colleagues on that.
All right. How much time is needed by the parties?
2 weeks.
That's fine. A couple weeks.
All right. A couple of weeks, and then we can address that. Next, I want to turn to address media coverage and place on the record the potential consequences of any willful violation of the court's December 23rd, 2025 standing decorum order. Under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. Any alleged violation will be carefully evaluated, and the court will impose only those sanctions which are appropriate and proportional under the circumstances. The court will make specific findings on the record before imposing any sanction. In addition, the court may impose the following remedial measures if warranted. First, immediate suspension of video transmission of the hearing, with proceedings continuing on audio-only basis for the proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with the standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules.
Have you seen anything like this at the drugstore?
What are you doing,
No,
Court
you
TV?
haven't. Look, Optic is making the most beautiful
You are the worst.
readers. This is Laurel and
You
Champagne.
are the
I'm wearing
worst.
a progressive lens, which means it's
Okay, let's find, guys. Sorry about
in a
that.
car or watching TV.
Yeah,
I don't
we're
have
not
to
gonna
set
do that. Let's find another outlet here. That is going to be intolerable. We will not watch court TV. I know KSL News has it, I believe. Okay. They are Let me get it to where we are. Roughly. Okay, let's share this. Can we not watch theater mode?
Operator. Mr. Yulberg's discomfort, I simply want to ensure that the guidelines for today's proceeding under applicable rules. Rather, they're intended to protect the constitutional rights of all operator. Mr. Yulberg, if you wouldn't mind imposing any sanction. In addition, the court may impose the following remedial measures if warranted. First, immediate suspension of video only base and disqualify the news organization that filled for the hearing services in this compliance with the standing, provide their input before the court makes any final determination regarding sanctions.
He's just been talking about potentially
sanctioning
sanctioning
that these
camera
measures are not
operators.
intended to have a chilling effect
Not that he is.
open and transparent courts or on responsible news gathering. And the court remains fully committed to the presumption of open proceedings under applicable rules. Rather, they're intended to protect the constitutional rights of all parties while preserving the integrity, openness, and fairness of these proceedings. Third, at this time, I wish to address the camera operator. Mr. Yulberg, if you wouldn't mind coming forward and standing at the lectern.
Interesting.
And could you state your name for the record?
John Yulberg.
Thank you, Mr. Yulberg. It's not my intention to cause you any embarrassment or discomfort. I simply want to ensure that the guidelines for today's proceedings are clear. Mr. Yulberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 Standing Decorum Order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 Standing Decorum Order, or any time to reposition the camera to ensure full compliance with those guidelines?
Do I need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound question. Sorry about that.
No, I've read it. I fully understand it. I'm good to go.
All right. To the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Yulberg, do you anticipate any difficulties complying with the December 23rd, 2025 Standing Decorum Order?
I do not anticipate any problems.
All right. And is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right. Thank you, Mr. Yulberg.
Thank you.
Before I let you go, I'll turn to counsel based off the questions asked. I turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right. All right. And,
No risky
the
Zooms.
court,
Mr. Yulberg.
I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor. I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point. There still is discovery coming in, there are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
None at this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, or sorry, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide at what stage the hearing on this motion remains open and becomes
Uh-huh.
closed. So
There we
I'm
go.
gonna
Absolutely.
bear that in mind in terms of my preliminary statements, if I may. When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is
There we go.
refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys in a potentially conflicted office and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received, and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray or from the other attorney. We have argument. We noted in our reply that we were surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the state was not being represented through the Attorney General's office. We did some further research on this and you know, we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion so that the boundaries are clear, or if there's an ultimate finding or conclusion that there's a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case and representing the state in a situation where there should be what I would call at least temporarily conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests. There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's, county attorney's office, that what's in the interest of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage, that's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Okay.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident. And we think that what the court should do if the Utah County's attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask hypothetically the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark because, as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office and they have not been consulted about this. Okay, so this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate. Their position as their own advocates is we've already decided no screening is necessary. So we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong. And we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion, the court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So that's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty good about that. So that's where we are before we even get into the litigation of it. And I don't want to be formalistic, and I'm certainly not trying to be confrontational, but I think actually what we think the court should do is the court should strike the Utah County attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state think they should, how it should be responded to. And if I've muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so and I'll try.
No, you've just been a little long-winded.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously you came into this hearing knowing that this is something you're going to present. And this court wants to be efficient with time, but thorough.
Yes.
And not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time to, and we wanted to get that filed in time for today's hearing because the court had set the hearing. It took us a little bit of time to think through these issues. So there are Utah authorities, there are authorities from other jurisdictions. There are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like, go back into chambers, think about it for, some pressured period of time and come back out and make it.
Well, you could have filed it
So
ahead of time.
It would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities. We're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court,
Why don't you say it for like the
is open
fifth
to
time?
receiving authorities, that we recess this hearing for, or, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position based off your request, to prepare the court, prepare opposing parties, and to be efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing, to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think compel what I've just suggested should happen. We noted in our reply brief that the county attorney should not be representing themselves. And that's probably an inadequate message to the court. But we did file a motion to disqualify. And inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial
You could have
authority,
made that request
which,
right
as
off
I've
the
done
bat.
for the research, and Mr. Bird and Ms. Visser and Ms. Nestor and I have all done for the research literally up until earlier this morning. We think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword if the court thinks I should be sanctioned for not bringing this up sooner. I hear the court, but we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not aware of, but the court can imagine.
No, and I appreciate that. It's not the intent to sanction you. I understand that issues come up and there's a lot going on. And so the court appreciates your candor and representation today. So these items can evolve. And so the court is not finding fault with you. It's just hoping that as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties. We just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the
It's a
court
battle of
devotes
politeness
to preparation for these hearings. So that's all I can really say.
Sure. And also for Mr. Robinson himself and the victim representative, Ms. Kirk as well. We just want to do our best, and I understand. And I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happened, so I understand. I'll turn to the state. Oh, and I'm sorry. Is there anything further that you wish to represent?
No, like I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think with all consideration for
Make your own decision. He's not going
we
to tell
probably
you
have-
how to
yeah,
litigate
with all
your
consideration
issue.
for the fact that the court wants to be thorough and careful.
Good Lord, be a leader in the courtroom
And we
and
do
just
as
do
well.
it. Tell them what you're going to
We
do.
don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way. Once we understood not only the way this was developing, but frankly, the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now. If you'd like to list them, court is ready.
So the second one would be State v. Robertson, and that is also a Utah case, 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any Utah rule on point that addresses this issue?
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course. Thank you. Turning to the state, Mr. Gray.
Mr. Gray is going to do it himself.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them more than a week ago, I don't know why they wouldn't at least notify the court. I too represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic to delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too?
Back in the meta world.
I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
Yeah, I
Mr.
do.
McBride.
And excuse me, this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts. From the few minutes I've had to read those cases, I do want to state this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case. But in the alternative says, we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion or memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion or the request the defense has made assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
Appreciate the brevity.
There is one other point I wanted to make, which is the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed. That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or alleging conflicts. There's a lot of case law that talks about how it can be a tactic to try and remove cases from one prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to seek, for example, in this case, the death penalty. And there's a lot of case law that talks about you can't call opposing counsel as a witness in a case unless they're absolutely necessary. And the reason is because it can be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled, you allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Now, we're ready to go forward today. We think the evidence that will be presented today will illuminate the issues adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the filing of a motion addressing more fully this issue. And to that request, what is the state's reply?
We object to that motion to continue or to strike. We asked the court to go forward today. We think the motion is untimely. The court has, or the prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed. These people are ready to move forward and get this out of the way. The longer we delay this, the more anxiety that this procedure has.
All right. Thank you, Mr. McBride. To defense, any response?
Yes, John, thank you.
Can we get it done today?
First, I want to say this is not about seeking a lenient prosecutor. This is not about tactics at all. And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present at Utah Valley University
We know.
at the Charlie Kirk rally and experienced and witnessed certain things. We didn't make this up out of whole cloth. We didn't grab onto some piece of discovery and say, a wedge, a tactic.
No, but you waited 3 months.
The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out of whole cloth because, like I said, we found a needle in a haystack. It's something that they properly brought to our attention, but we firmly believe that the law supports the conclusion that that particular prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way. And there was no effort to screen off that prosecutor. And that has now created a problem for the whole office. That is not made up out of whole cloth. And like I said, it's not about tactics or lenience or delay. This isn't delaying anything, at least on our part. The other thing that I want to point out is to say that until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict.
What's the harm if they find a conflict?
At least temporarily have the attorney.
I'm not getting the problem.
Handle this. Yes, Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A judicial officer decides to become a prosecutor. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from, as Your Honor knows. A defense attorney changes careers and becomes a prosecutor. There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack. It's not a tactic. It's not a fiction. It's not a thin reed. The evidence that the court has suggests, number one, that there's a very good possibility that as a legal matter, there's a conflict of interest. That's why we need to have an evidentiary hearing because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on without consulting with anybody that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend the decisions that they've made. But the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right? Because to quote the law and to quote the ethics, the Utah County Attorney's Office is now serving two masters. I don't like that word, but that's the word in the doctrine. They're representing themselves.
Talk about
and they're representing
circular.
the state of Utah.
Kind of assuming your
And
conclusion,
that's
aren't you?
why the Attorney General or somebody else designated by the Attorney General should be representing them in this matter. And I do want to say one more thing, if I may, Your Honor, and I appreciate the court's patience. I think that the way we raise this issue in our reply brief is not as accommodating to just letting it go as counsel suggests. What we said is we asked the question is whether it is even appropriate for the UCAO to litigate this issue on its own behalf. While the UCAO may have provided this court with the information that it has deemed relevant to this issue, the scope of the disclosures and litigation of this motion should have been assigned to another state agency, such as the Attorney General. We didn't suggest that this court should appoint a special prosecutor for all purposes, or that the filing of this motion means that the Utah County Attorney's Office is automatically disqualified from the litigation. That's the point of the motion, is whether they had a conflict of interest, and if they did, whether they handled it. And it's our position correctly, and it's our position that the answer is yes and no. So I understand there are witnesses here, people are ready to go. We think that the court should either accept briefing or agree with us that the referral is appropriate. And I want to cite, if I may, the citation by the Supreme Court in Jimenez. So this is 588 P. 2nd. It's 707, but this is at 708. This is the statute quoted by the Supreme Court. If at any time after investigation by and a finding and a recommendation from the district judge involved that the county attorney in any county is unable to satisfactorily and adequately perform his duties in prosecuting a criminal case without additional legal assistance, the Attorney General shall provide such assistance. That's very broad. What that means in this case is it's inappropriate for the Utah County Attorney's Office to represent itself when it is also representing the state. And that for this motion, this court has the discretion, we would say, respectfully, the obligation to designate the Attorney General to represent the state, the people of the state of Utah.
We
in
know
this
which
motion.
people.
And depending upon how the
Familiar
court
with the state.
rules on the motion, then we have to see what happens next.
So is it your position that the court has discretion to make that decision?
I think that the court has the discretion to
Trick
say
question.
to the Utah County attorneys, you shouldn't be representing yourself in this case at this stage as to this motion only. Continue to do what you do while this motion is pending, and we will resolve this motion. I am not suggesting that they should stop the work that Mr. McBride talked about preparing discovery, having their agents interview witnesses. We want to get this motion resolved in a timely way. It is not a stalling tactic, but I'm not saying, let me be very careful because I don't want to misinterpret the court's question. I'm not saying that whatever this court decides is the right decision because the court has discretion. We believe that the law requires that the county attorney's office be represented by somebody else for this motion. What I'm saying is the legislature gave the court the authority to compel that when the state attorney and the attorney general haven't done anything about that yet. I'm not saying that the court, I mean, I don't know what the standard of review on appeal would be. So I'm not just saying it's an abuse of discretion standard. What I'm saying is the legislature gave this court
You saw the trap.
the authority to direct, refer to the attorney general representation in a criminal case where there's a showing of a potential conflict of interest. And I've been a criminal litigator, although on this side for a long time. So I understand what counsel's talking about is sometimes defendants come up with questionable grounds and move to disqualify.
No
And
kidding.
I don't think that that's a finding that the court can make in this case. It was actually, as I said before, the Utah County attorneys who were concerned about this enough that they brought it to our attention. We have profound disagreements about the significance of the conflict and the way it was handled. Okay, and otherwise, I think I would be repeating myself if I said anything more without answering a direct question.
All right, I just have a brief question. Do you have your witnesses here today?
All the witnesses are here. We have no problem as a pragmatic issue going forward. Our witnesses are
They're going to go forward.
the subpoenas that we served, which were filed with the court. So to be clear, I don't think the court is inferring this. We're not unable to proceed if that was the court's conclusion. We are prepared and the witnesses are here. I'm just saying we think that it would be improvident and it could result in errors of law and it could result in problems down the road.
Thank you. Do you need any additional time in regards to your argument to continue this hearing based off the citations you've provided, the authorities you've provided the court?
1 second. No, thank you.
All right, thank you. What this court intends to do is, this is an important issue. And I realize the totality of what's been presented. And my question in regards to your witnesses it was informatory. I just wanted to see if depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue and this court wishes to take a brief recess.
We're
I
going to
want
look at the law.
what's been provided and make see where the court needs to go. I want to inform myself, take a moment to look at it, and as opposed to just making a snap decision and taking into consideration all parties and the constitutional rights of all parties as well. With that, we will be in a brief recess. I always hesitate to give the time because
We'll be
sometimes
here.
I appreciate
15
you being here.
minutes.
Court is in a brief recess. Thank you.
All right.
Ooh, let's mute that. Okay, so now we'll be able to get caught back up with the live feed since we were so unceremoniously dumped into ads by Court TV. Guys, I do have premium, so I don't know why that was an issue. But anyway, whatever. We've got it sorted now. So well, what an interesting morning so far. Let's do our recap. The 4 preliminary matters. So first off, the 1211 transcript that was designated private. They're going to release a redacted version. This is the meta problem that every time you seal something, you have to have a closure hearing on the sealing, which is then itself closed, which you then have to have a closure hearing about, which is then closed. And it's creating this perpetuating problem of, having to have these closed hearings that then have to be addressed in closed hearings in order to decide what gets released publicly. This does not seem efficient at all to me, but I guess this is what it is, and this is the cost of them deciding they want to close the courtroom doors from time to time. Keep files out of the public record. There's more of those, by the way. When we get a chance, we will talk about those. the media coverage, calling the cameraman, Mr. Yulberg, up there to the stand to question him specifically about making sure you understand the ground rules here. And do you need, it was the most polite, very clear warning that I think I've seen from a bench. Like, first, the laying out, here's what could happen. You could be convicted and thrown in jail for 30 days. You could be fined thousands of dollars. We could yank your outlet's authority to serve as the pool operator if there's any violation, willful violation of the decorum order. So now, Mr. Yulberg, you sure you understand that? Do you need any time? Do you have any issues you need to bring to my attention that might make it difficult for you to comply with that? No. Okay. So we won't be having any risky zooms then, will we? That was the problem we had last time when they reoriented the camera. Then they zoomed and you were like able to read the papers the people were holding at their table. Just another big no-no when it comes to the camera operation. But all that being said, this seems to have worked far better this time. I mean, they, of course, have to do their little pan and zoom to Tyler. They got to get the close-up of Tyler with his like kind of longer, little greasy-ish hair today. Didn't get a haircut before this particular hearing, which is fine. He doesn't have to if he doesn't want to. But, you know, they're not getting the table. They're not... otherwise being too terrible. Now the sound management we could perhaps criticize a little bit, but at least the cameras seem to be on their best behavior today. So as kind of awkward and potentially intimidating as that was, it seems like it got the job done, didn't it? And in the politest way possible. Very polite. Mr. Yulberg, I don't intend to embarrass you. I don't intend to suggest or chill anybody's interest in news gathering and open courts. I remain committed to the constitutional principles of transparency. We really appreciate that, Judge. He has been quite good compared to certainly a lot of judges that we have seen lately. Status of discovery, it's still going. They have just about provided their initial batch. We heard at the last hearing that what happens is the investigators dump all of their reports on the prosecutor's office, and the prosecutor then has to go through and do redactions and things like that. So they have to review everything before they provide it to the defense. And that's what is taking up the time. So that's ongoing, but they're nearly done with the initial stuff. It's time consuming. Granted that it's an ongoing process. We know it's an ongoing process, and they discussed some of those details previously. Like, for example, they talked about how they've gotten a whole bunch of video footage from UVU, and that, for example, they're looking, they're going through it in reverse order from the day of the shooting back. So they're clearly looking for evidence of casing out the place, basically any kind of preparatory steps that were taken for the shooting. So a lot of that kind of stuff is, of course, only happening after the fact, after they've identified their suspect. And it's going to take time to go through all that and hand it over. But they are nearly done, which I would think puts us in a pretty good position for that May preliminary hearing that has been scheduled. It gives the defense 4 months, roughly 4 months with the discovery. And so then the motion to disqualify. So we already knew, and they both seem to agree there are going to be a point where they're going to close this hearing. Maybe not the whole thing, which is, I guess, something of a relief, but we know they're not going to put the prosecutor on the stand in front of everybody. We know they're not going to put the prosecutor's relative on the stand in front of everybody. The other people maybe, because they can just be careful with their words, and how they identify people. But the actual people at issue whose privacy interests they're protecting by having all these redactions and stuff like that, if they've decided that warrants, being concealed from the public, which I might question, but can't say I've done a whole lot of research into like what the legal basis is in Utah to withhold that. You can't conceal the identity of the people when they're on the stand. So judge says absolutely, yes, he agrees. Absolutely, at some point there's going to be a closure of the hearing for that purpose. But then we got just swallowed in this quicksand of the process about the defense team thinks that the AG should be handling the response to the motion at all, and the judge is like, well, why didn't you bring that up before? And my thought process here is like, yes, if you're asking to disqualify the Utah County Prosecutor's Office and you're asking to disqualify them for purposes of responding to your motion to disqualify, those are two separate asks. You can make them both in the same motion, but you should at least make them. Like if that's your position, you should ask for it. But their view is just that because the county is the representative of the state, that it's improper for the county to have a position on the conflict. I mean, I have mixed feelings about this. This is not real uncommon in litigation for conflicts to be alleged, and you get to represent yourself. Like, that's fine. You get to defend yourself because there's always kind of an implicit, even if it's not like a real overt accusation, it's still there. There's this implicit suggestion that you're not complying with the ethical requirements that you have, your ethical responsibilities to not be involved in cases where you have a disqualifying conflict. And so you typically get to defend yourself against efforts to impugn your professional integrity. And so then, yeah, once a decision is made, there's a conflict or there's not a conflict, then you decide, how to handle that. But I'm trying to think of a situation, if I've even seen a case where a prosecutor brings in a special prosecutor just to litigate whether the prosecutor has a conflict of interest. I can't think of a situation where I've seen it. I mean, I'm not going to say it's never happened. But I don't think it's particularly common, because you do what they do here where you litigate, and okay, they get to put on their evidence and you get to put on yours, and maybe, we get to vet it through a hearing where cross-examination gets to take place. And the judge makes his decision based on that. So I can see the reasoning behind it and why they think that's appropriate, because yeah, I mean, a perfect system, you would do that. A perfect system, you would bring in somebody completely outside with no dog in the fight whatsoever, to decide, number one, should we even contest this? And, on what basis, do their own kind of independent investigation to evaluate what the factual situation is. That would be the perfect process. It's hard to argue against that, at least in terms of an ideal. It's just that there's not a whole lot of perfect processes in the court system at all. I mean, it's a very common thing to be expressed that, like, the defendant, for example, he's guaranteed a fair trial. He's not guaranteed a perfect trial. You hear that all the time. That's a very common theme that comes up a lot. And so I'm just not sure that this perfect standard is really necessary, if it's adequate for the prosecutor to be able to assert their position, and the defense gets to assert theirs, and the judge gets to decide, where the facts lie, and based on that, is there a problem here with this prosecutor continuing? So we had a rather long-winded, repetitive defense lawyer Only thing he said that I thought was sort of interesting was that Kathy Nestor had spoken with the AG's office to find out if the AG's office had conferred with the Utah County Attorney at all, and that they hadn't. Does that matter? I don't know that it really does to me. When you have concerns about ethics, I don't know how it works in Utah, but a lot of places will have ethics advisors very specifically, often through like the bar association or something like that. Those were the people I would imagine you would contact if you wanted to confer. Or, you've got another prosecutor in another county that you run it by them. What's your take? Defense lawyers do this type of thing all the time. You just reach out with your colleagues and kind of bounce ideas off them and get their impressions. I don't know if there's any reason it's specifically you got to go to the AG. But they made the decision themselves, which is not really unusual. Can't say that's really unusual. If somebody asserts you've got a conflict and you think that's kind of, that's kind of lame, it's kind of not a good basis, I'm probably not going to talk to it about other people. It's when I think it's a pretty good challenge that I'm far more likely to be, ooh, did I mess up? Is this something bad? Has this, evolved in a way that, I need to get myself out of it. And the judge is right. Things do evolve, and that often happens with post-arrest investigations. You discover new witnesses. This is very much the case with the defense lawyers because you don't get the discovery until after the fact. They're October, November, December, they're 4 months into the case. And they're only just now, having pretty much all the discovery. It's real common that you can be going through that and realize, oh, here's one of their witnesses that they're going to call, and he's somebody I'm representing in another county, or something like that. You don't always discover the conflicts until later. So these things do happen. They do evolve. And it is what it is. Everybody's kind of used to dealing with that. But I can understand the judge's frustration here with why are we just dealing with this right now? Why didn't you file something before? Why didn't you give notice? If this is the process that you thought needed to be followed, then you should have asked for that instead of just taking it for granted that that's what was going to happen. It's not clear to me that they even communicated to the prosecuting attorney. And from the prosecuting attorney's response, where he's like, look, we talked to them about having a continuance and stuff because they filed it late. And then the response deadline was going to end up like right in the middle of the holidays. So they got an extension to file their response. And apparently no conversation in the course of any of that about, so you guys are responding yourselves, and do you really think that's appropriate? And did you ever consider sending it up to the AG? I mean, doesn't sound like there's been any quote unquote meet and confer on this process at all. The little back and forth, the battle of the politeness. I wrote in my notes here, it's like fencing, but passive, where they're just crossing swords with their little niceties, the judge and the defense lawyer. No, I'll follow my swords, judge. Oh, well, I'm not intending to, do anything. And well, I don't mean any disrespect to the court. Well, I appreciate your candor. It's this fencing of this very just not aggressive at all, like deferential kind of way of engaging with each other. Which if this goes on at court, honestly, it's going to annoy me. It really is. A passive lawyer is it's very annoying to me because your job is to make motions, is to ask for what you want. Be clear, be direct. Just this whole, whatever the court wants me to do, I'll follow the court's guidance. This is not an approach that I like, because you're not putting yourself in a very good position to be unhappy if you don't get what you want for the first point. But I just really question whether this is good representation of your client if you're not just do what your client is best for your client. Just do. Don't ask. don't ask, just do it. If the rules don't say you can't, then just do it. Just file your motion. I mean, I don't know why you wouldn't. Anyway, the elected, of course, then has to have his say, which is always interesting to see the elected make a personal appearance in court, because they often don't. By the time they're elected, their duties are so broad now, they extend so far beyond just what happens in the courtroom. Very common that they don't have a trial docket, they don't have a caseload. Or if they do, it's very limited and selective. They don't do a lot of court appearances. They're busy dealing with county governors and the law enforcement and policies and all of these types of other processes. But he, seems to be taking it a little bit personally and asserting that he's the constitutionally elected prosecutor, and that's what I was pointing out at the beginning here with that law review article that I was reading. That is really the concern that a lot of judges are going to have in this situation, that this presents a potential separation of powers problem, because he's the people's chosen executive for courtroom justice. And so for the judge to step in and interfere with that, he's got to have a solid reason to do that. So whether it fits within those rules is kind of an open question. Prosecutor just basically saying it's a surprise to us. We weren't expecting this. Had no notice that this was going to come up today. We've got the witnesses subpoenaed. They're here. It's the witness who was there, a prosecutor, and 2 investigators have been subpoenaed. They told us. He argues, and I think it's a good argument that suggesting they have to bring in this third party to file the response is presuming that there is a conflict. They both have their argument for circularity. The defense is arguing, well, it's circular because if they defend themselves and then it turns out they shouldn't have, then they shouldn't have been representing themselves. But the problem I have with that position is that if they had a conflict and they represented themselves and the court found that there was a conflict, then them representing themselves didn't cause a problem because the conflict was identified and dealt with. So it's a little bit, it just strikes me as a little bit formalistic, this concern. It's far more of a concern if they, represent themselves and the court does not find a conflict. And now you have the implicit threat that was kind of there from Mr. Novak at the very end. Well, but this could result in an error of law. This could result in a problem down the road. It's going to be an appeal issue. You might as well just go ahead and come out and say it. It's going to be an appeal issue. It doesn't sound like it's going to be a particularly strong appeal issue because it doesn't sound like there's really law that's directly on point one way or the other, but it's hard to say when the prosecution's kind of response on the cases is that, based on a 5-minute reading. But the defense is saying, look, there's a statute. It says you have the authority to do it. Judge had that little trap. Are you saying it's in my discretion to decide whether the AG should handle this response or not? It was a trap, and Novak spotted the trap because of its discretion. Then it's really, really hard to argue with his decision. If he gets to decide if that needs to happen or not, then it's very hard to second guess that. The standard on appeal, the standard of review on appeal is basically no reasonable judge could reach that decision. And if this is kind of an open area, which it seems like it is, then it's fairly hard to reach that conclusion. So I think ultimately, if there's no binding authority that is really directly on point, and this judge is kind of faced with this issue of first impression of, am I required to bring in the AG to do this response? Do I have discretion to decide if it's appropriate to strike or to strike their response and require the AG to respond or to have the hearing go forward today? I think he's going to have the hearing go forward. I think that's very likely. They are all here. Nobody wants to waste the time. He's already articulated his interest in making efficient use of our time. Doesn't mean he won't. But if there's no law that really says this is what you have to do, then I don't think he's going to be inclined to do that. But we'll see. I guess we'll see. So now we wait. Hey guys, before we get too much further, I did want to mention, because I forgot at the top, and I saw a couple folks very generous. I always appreciate the support for the channel, the super chats and things like that. But I did actually have a special ask for today. I wanted to ask anybody who was potentially inclined to support the channel with a super chat or something like that, to please not, and to consider instead sending your support over in this direction. Let me pull it up for you here. We've got over at our gym, we got 2 kids that are going to nationals, and this is very exciting. This is Danny and Malyia here. Danny's 11, Malyia's 12. This is like their first big opportunity for a high level competition. So they are the Washington State champions in the silver gloves, and this is their chance to go to nationals over in Kansas City, Missouri. So we'd love to be able to help them do that. These kids, okay, so yes, this is my gym. I've coached all these kids for a long time. Like Alex over here on the far left, I've known Alex since he was like about knee high, and same with Chris in the middle here. I've known Chris since he was probably about 8 years old. And so like seeing them, come up is just, it's a very awesome thing. And Danny and Malyia are getting started really early. This is just a great opportunity for them, because it's a chance for some excellent high level competition. And this is the kind of thing that I'm not going to say like it makes or breaks you or anything like that, but it's a taste of what really high level competition is like. And so, if it's something that they enjoy and that they aspire to and stuff like that, this is, how you get up on the path to like Junior Olympics, and like maybe, you always fingers crossed someday, like you could be on the Olympic team or something. We always have dreams for our kids, and these ones have both worked really super hard. We're so proud of them. We really want them to be able to go. Got a little bit of stories about them here. Danny started competing in February of last year. He's got a lot of fights so far. I want to say about 10. I don't want to say for sure. Malyia started competing just in September, and she doesn't have nearly as many fights. The girls never do. It's hard, much harder for girls to get fights, period. Than it is for boys. But she has been competing every chance she gets in like the local and regional kinds of bouts and stuff. So anyway, if you guys would be so inclined to help support out Danny and Malyia, we so would appreciate it. And so, not to take away from anybody's generosity or anything like that, because I very much do appreciate it, but I had been meaning to make that ask early on, and then I forgot, and then I saw people sent me super chats that we're gonna look at and talk about now. So, To Truth for Liberty. If audio forensics, e.g. cone of supersonic bullet sound waves of a physicist, expert peer-reviewed, reveals a path that could not have hit CK, would failure to call an expert be ineffective? Potentially. I mean, there's a lot of things that have to go into a question like this. What you're basically going to be dealing with a post-conviction type of process, right? Because so first off, if they didn't call an expert, then you don't have any record of what that expert would say or do or anything like that in your trial record. So it doesn't come up in a direct appeal. It's only going to come up in a post-conviction process, like a habeas petition or state equivalent to habeas. So you're going to wait a while to get to that point. But then you're going to have a kind of threshold. You're going to have to show that, this is valid. This is a valid methodology under whatever the rules of evidence are in Utah for the admissibility of scientific evidence. I don't know if Utah is a Fry state. I don't know if they're a Daubert state. I don't know if they have some other standard for admitting scientific evidence, but you need to show that this meets it. So ideally, there would be other cases where it's been shown to have met that standard that you can rely on. Because if not, you have now a much higher hurdle of, we could show that for the first time, this is, admissible under the scientific principles for evidence in this court. But if you can do that and you can show that this is exculpatory, you can bring it up. The question is it going to change the outcome? And that is a question that always depends on the totality of the evidence that's presented at trial, because it's not uncommon to have things that can conflict. You might have really, really good evidence, except the ballistics aren't super solid, but that's because it's, ballistics is maybe a little bit of a soft science. I don't know how good this particular methodology is. I don't know how much opportunity there is for distortion, things to be affected by like environmental conditions or building materials or stuff like that. I really don't know much about it. So you'd have to make a very good record, but I mean, at least in theory, yeah, this is possible, because if it's something that the defense had, didn't use, would have been potentially outcome, determinative, would have been admissible in court, then it would be ineffective not to use it. To Truth for Liberty, if someone in the public sent an exculpatory forensics analysis report to the prosecutor's office, would the state be required to provide that to the defense as part of discovery? So I am never going to encourage anyone to involve yourself in an ongoing case. Don't do it. It's not a particularly good idea. But generally speaking, as far as Brady goes, yeah, the prosecutor has an obligation to produce materials that are potentially exculpatory to the defense. The bigger question is, what, if any, duty do they have to go through the mail and look at it in detail and take any of it seriously? It's not necessarily, clear that they do. So that's where I think you run into a little bit more of an issue is, does the prosecutor have a responsibility to look at random things that they get from the public? That's a little bit more of a gray area. So answer to this one is a big maybe, but I do not encourage anybody to be sending stuff to the parties here. Nicolaire 3352, so happy to catch your live and analysis today. I'm glad you're here with me. You got a little kitty cat there. We had Gus with us for a minute there. Gus is the one that he's always in my lap. He's the lap pirate. Like, of all of the cats, he's the one that most likes to be in the lap. So that's why Gus shows up on stream so much more often than anybody else does. But he does have his cone. The boys had their preventative snips early this week, so they're wearing their sad little cones, but everybody seems to be feeling pretty good and not really that much worse for the wear. This is their last day on painkillers, so they're kind of slightly sedated cats still at the moment, but that shouldn't last for too much longer. Brandy McMahon 4061, is this a delay tactic? Well, the prosecution certainly thought so, didn't they? I mean, they called that right out. This is a delay tactic. Kind of seems like it might be, huh? Kind of seems like it might be a delay tactic. I mean, of course the defense is going to deny that. They're going to say, well, this is about doing it right. This is about making sure that we are following the right process, that the form of what's done does matter, just like the substance of what's done matters. But the practical effect of it is certainly going to be to delay, if not, a lot of stuff, at least the resolution of this motion, right? Because we're going to now, if the defense gets what they want, we're going to have to reset the briefing schedule, because we're going to have to get the AG notified. We're going to have to get the AG appointed. They're going to have a chance to review everything. They're going to have a chance to investigate, ask all of their own questions, develop their factual record, prepare their response. And then depending on that, what their response is, a reply, and then we have this hearing all over again, potentially. If the AG gets involved, would that maybe mean we don't have to have witnesses testify? I doubt the defense is going to take that position, right? The defense is always going to say we have the right to challenge their presentation of facts and to contest it. So, I mean, yeah, the practical effect of this is it's going to delay this motion. And so then if the motion is delayed, say a month, then we're not having a hearing until early March, end of February. And then what? And then how fast do we get a decision on it? What if we decide there is a conflict? We decide there's a conflict, but we don't get a hearing. We don't get a ruling on that until mid-March. Well, now we've got, 2 months before the preliminary hearing. And now we have a new attorney that's going to come in that has to get prepared for the preliminary hearing. Does it seem likely that that's going to also be delayed given the huge volume of stuff that we keep hearing about? So I don't know if it's a delay tactic, like explicitly, overtly, but there's no question that the effect of it is going to be to delay the process. And so if you're asking for something that's going to be the outcome, maybe that's not your whole goal, but certainly you don't have a problem with it. Mavka in Sky, drop that Vision Elite. Try Lamy Safari. Okay, I'll write it down. But I will tell you, you're going to have a hard time prying my Uniballs out of my hands. I've tried so many pens. I mean, most lawyers have, I'm sure, but I had the little special experience during Delphi of, going through boxes and boxes of pens. And so just because of how many notes I was taking. And so I got all kinds of pen recommendations, and the stores in Logansport, Indiana are different than they are at home. So you can't find your favorite pens. So you got to try out other pens. So I tried out a lot of pens. I have to tell you, I have yet to find a good pen to beat my my old Uniball Vision Elite. But I wrote it down. I will try your Lamy Safari. Thank you for the tip. Gingerpuff 764. I thought Tyler Robertson's parents could not be photographed. I saw TR's father in a wide shot. Does that count? Yeah, I'm afraid that probably counts. I noticed that pan back to the audience and thought, that's a little bit of a risky move too. That's a little bit of a risky move. Don't always want to have the family shown on camera. Let me go ahead and pull up, because of course I'm sure I have it somewhere. Just have to find where the decorum order is. September 24th, 2025 decorum order. And there's a specific section that deals with the cameras and news reporters. And let's see here. No audio is permitted of conferences involving counsel. No visual. Here's the part I was thinking of from before. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Both of those things happened at the last hearing, the lip reading and the having the ability to read what's on the papers. Okay, so there is nothing in this specific order that deals with Tyler's family. So here's what I think happened. What I remember is that during one of the in one of the requests for electronic media coverage, and I think it was the one for the last hearing because it was the first live hearing, so they expected the audience. There was a notation specifically on that order to not photograph or video the family members or witnesses. I'm going to see if I'm not going to be able to. Yeah, here it is. I was actually, look at that. I was able to just pull it up on the first try. I'll show you where that's from. I'm going to have to hope that we don't suddenly go live real fast because I'll have to get us back on there. All right. Can you guys see that? Yeah, here it is. So it's this, it came from this request for electronic media coverage for the December 11th, 2025 hearing. And they put in this special notation here, the special limitation that additional exclusions for this hearing are no electronic media coverage of victims' family members and no electronic media coverage of Mr. Tyler Robinson's family. So because it was only in this order, I think it only applies to this hearing. I think it only applies to that hearing, unless he wants to incorporate this into the standing order or unless he continues to include these restrictions in future decorum orders, then I don't think they're going to have a problem here. It's not very seemly, in my opinion, for them to do that, but I don't think it specifically is outlawed. Let's see. Okay, so we are still waiting for KSL. Mafka in Sky. Vision is my long favorite store pen. Lamy is Amazon. Okay, I will give it a shot. I will give it a shot. Amazon. I'll even make the note. That means I can get them fast. Hey, great. Good stuff. Nicolaire 3352. I grew up in the 80s and it seemed like we saw family members and defendants during trials without a lot of pushback. Yeah, you know, I've been thinking about this a lot, a big part because I've been watching the Jim Martin trial, which was back in 2012. I've been rewatching that since the Christie movie came out. This was about Jim Martin's attack on Christy Martin. Looks like we are back in court here, so I will be ready.
Brought up are important, and the court wanted to take the necessary time to examine what has been presented and make a decision on how we move forward today. And the defendant's or defense's argument, and the defense relying upon Jimenez and Robertson cases, if there is a showing of conflict of interest under Rule 1.7, then the court should exercise its discretion and require the Utah Attorney General's office to stand in for the Utah County Attorney's Office. Mr. Novak conceded that there has to be a very good possibility of a conflict or showing of a conflict. No authority was given to the standard of proof necessary to satisfy that showing. This court wishes to address the issue of the showing of conflict of interest under Rule 1.7. And with regards to the first question, whether the prosecutor has a conflict of interest under Rule 1.7, the defendant asserts the following facts, and I'm drawing from the motion itself and reading from it. One of the prosecutors on the case has a family member who, along with approximately 3,000 others, attending Turning Point USA at UVU.
He doesn't care.
On the day Charlie Kirk was shot and killed, the family member texted the prosecutor almost contemporaneously. I can't speak today. Contemporaneously.
Contemporaneously.
I said that word right. With the event, and shared that they had heard the gunshot and that they had run with the crowd and other observations, feelings, and reactions. Thereafter, the prosecutor went to UVU and investigated how far away his family member was to the shooting. The family member had left a backpack when they fled. The prosecutor determined that the family member was approximately 85 feet away from Charlie Kirk when he was shot. In my view, those are the alleged facts that the court must consider to answer the first question. Does the prosecutor, by virtue of his relationship with a family member who witnessed the shooting, have a conflict of interest under Rule 1.7? And turning to that, just looking at my notes, I appreciate your patience. And so turning to defense, If I accept the facts as you have alleged in your motion as true, is there any reason to call witnesses to answer the first question before the court? And before you answer that, I understand that there are other relevant facts that pertain to the effect of the alleged conflict. Those facts would include whether the prosecutor was properly screened from the case, what conversations he had with other prosecutors, and whether the family member's experience impacted the state's decision to seek the death penalty. It is the defense position, as I understand it, those facts may need to be explored through witness testimony. But if we're just talking about the first question, whether the prosecutor has a conflict of interest under Rule 1.7, is there a need to call witnesses?
Yes, they're going to want to. They're going to want to explore the facts.
Yes, Your Honor. I understand that the court is trying to get to the threshold question that we have put before it with respect to who should be representing the Utah County Attorney's Office in this motion. But the answer to the court's question is yes, because it's not just the mere transactional event that this, that the offspring witnessed the shooting. It is the evidentiary development will get at, and again, we were only provided with an affidavit, which was very, if
You want to fish.
drawn,
Just say you want to fish.
communications that happened after that between that offspring and their parent, between that offspring and other family members that may have been communicated to the parent, communications between the parent and other people in the office, impact. Okay, so now I'm going to just say, if I had found out that my child was at an incident where somebody was shot and killed, I would have an incredibly strong emotional reaction, even if they were safe. Okay, so give me a second, okay? There was a horrible shooting incident at Brown University a few weeks ago. And I have a child who lives within 20 miles of there who was in Providence that day. And everybody in our family was really freaked out until we knew that they were safe. And then even when we knew they were safe, the question was, what did you see? Did it affect you? Turned out everybody's fine. But it's not just, oh, I was there, right? And my family member didn't witness a shooting. Wasn't in a crowd with 3,000 people who all had to run and take cover in case there were more shots fired, in case there were some other harm that occurred, okay? So it's not just the fact that this person was 85 feet away from Mr. Kirk. It's that begins to, that scratches the surface, if I may, of the totality of the circumstances, which we think.
But you want to fish. You want to fish in.
Created a conflict of interest. So the answer is yes, and that's why both the parent and the offspring are here and are under subpoena and agreed to be here and agreed to testify. Obviously, it's the court's proceeding, but nobody's moved to quash, and I think it's obvious that that's because we need further factual development. And our reply brief, if it did anything, it communicated to the court the case law, which shows that this is a fact-intensive inquiry and that affidavits are required. And here we don't have affidavits from the parent or from Mr. Gray. We have argument in a brief, but we also believe that testimony from the offspring is necessary, and they're here and they agreed to be here. And they agreed that Ms. Visser could sign an acknowledgement of service of a subpoena. So the very, very long answer to the court's question is yes, definitely. We need to have an evidentiary hearing.
But isn't defense required to make the threshold showing from the facts that you're asserting? Isn't that where we begin? Not necessarily the state's response, but don't you have a responsibility to show that you've made a threshold showing of what you're asserting would rise to what you're asserting in your motion?
So the state So the Utah County attorneys informed us that this offspring was present in a crowd, was caught up in the ensuing chaos, heard a shot fired, had to leave their belongings behind, witnessed the trauma of other people. We can't really get beyond that without fact development. And if what the court is saying, hypothetically, is, I want you to go sit down and interview people, that's one thing. But if the court's saying that we somehow should have more information than the county has given us, we can't do that without evidentiary development. Okay? We have questions about whether there were more non-recorded communications that we haven't been told about. I think we have a good faith and the court could imagine.
You want to
that
fish.
a family would talk about such an incident, and it wouldn't just be the text messages that the court has in the exhibit. And I don't purport to say anybody should run their family the way my family operates. I'm just talking about what I think would be natural, which is families talk about these things because we want to take care of our kids and we want to make sure they're okay. And then we need to make sure that our responsibilities to the public and to justice aren't impacted by our personal experiences. And I think that we can only get at that, Your Honor, through evidentiary development.
All right.
And that's why, and I think that the state would agree with that, because that's why they provided the court with some affidavits and some fact in the course of argument. So I think that it needs to be fully developed through the very limited number of witnesses that are present.
I understand. Let me turn to the state. What's the state's position?
So I want to make sure I'm understanding your question.
Poor Novak.
Question is, there's two layers here, right? The first layer is, when an alleged conflict arises, does in this case, the county attorney's office have to conflict the handling of that allegation to another special prosecutor, attorney general's office, right? Your question is, doesn't the defense have to make an initial showing before that first conflict or occurs that requires that delegation?
Yes.
Okay. My answer is yes. I mean, otherwise we have to have a hearing to determine if another entity has to handle the substantive issue. And then you have to have another hearing to determine if there actually is a conflict. I think there has to be at first a showing that there is, a basis for a conflict. Otherwise, someone can come in and say, I think there's a conflict without any evidence whatsoever, or not evidence that's credible. I think, and for that reason, I think the court should be able to make this threshold showing based on the affidavit, right? The affidavit and the facts have been proffered. I think there's enough there for you to say, yes, the county attorney's office can handle this motion on its own, or no, this motion needs to go to the attorney general's office, whoever else, to handle the substantive issue of whether or not there's a conflict.
No, do it based on the defense allegations.
I want to be clear. I don't believe under any of those circumstances that the issue needs to be conflicted out. I believe that until a conflict has been found, the county attorney's office or whatever entity has been accused of conflict can litigate that issue without litigating that issue.
All right.
Did I make myself clear?
I appreciate that, Mr. McBride. A follow-up question in regards, they're proposing calling witnesses to make that threshold showing. What is the state's position?
No, I mean, my position is no. I think witnesses should be called one time in this case, and that should be to determine whether or not there's a conflict, not to determine whether or not the issue of whether or not there's a conflict should be conflicted.
Okay. I think there may have been a little bit of confusion there, and I'll take responsibility for the question. In regards to the threshold showing
He's not catching the softball here. Rely
So
on the
the
defense
threshold showing of a
allegations is
conflict
what
of interest under Rule
wants.
1.7. So the AG's it seems to follow after in time to see if there's a conflict initially. So in regards to establishing that, defense, and I don't wish to speak for you, but my understanding is you wish to call witnesses to put that evidence on.
Then I misunderstood the court's question. I don't think
Oh, God.
we need to take testimony in order for this court to make a finding on under 1.7 that conflict-free counsel should represent the state in this motion. I am not suggesting, and I didn't mean to, that there should be 2 hearings. That's not what, so if I misunderstood the court's question, I thought the court was saying, do we even need an evidentiary hearing on your motion to disqualify? Isn't it enough for the court to just read the papers? But that was not, was that your question?
Well, and I'll take full responsibility on my question. That was really the push on it, because my understanding is that determination needs to be made based off what you told us in the beginning, that showing of a conflict of interest, there has to be a very good possibility of a conflict, or showing of a conflict is the very first step before we go down the further road of addressing the AG's office. And so I was alluding to, based off that, does that require an evidentiary hearing from your perspective?
I don't think that it requires an evidentiary hearing, but I don't want
You just gave
to
up. You just lost.
predict or make assumptions about the court's view. I believe that the
Judge, do what will make
Utah
me win.
county attorney's disclosure to us on October 20th of this situation and our assessment that it creates a conflict of interest is not frivolous. It's not taken for the purposes of delay or tactics. It's a real potential conflict. I don't know what the threshold showing is that permits or requires the court to exercise its
Good thing nobody was taking a shot every time
authority
someone
under
said
what is
threshold.
now in juxtaposition to the Utah legislature changes its code so often, like we have to figure out all the new code numbers, but it's now section 17-68-304, which gives the court the authority to appoint the attorney general in this situation for this purpose. 17-68-304.
He is,
As
Matt,
opposed
but
to
he's too
the
smart for his own
Code section
good.
cited in Jimenez. The law is the
Got
same.
himself
The code
out
section.
of his good
But
position.
what I'm saying is, I don't want to predict or gamble with what showing this court thinks is necessary in order to appropriately exercise its discretion to make that referral. And so if the court says, I need more, then we should have an evidentiary hearing, because the important thing is to get it right, not for
The
me to
important thing
bargain
is
on
for you to
whether
get what you
our
want.
papers show enough. The only thing that we know that we can show in our papers is what we were told and what we were given. And we were given some text messaging between family members and maybe some other people.
And you want to fish.
Exhibit. That's all we really have. And so I don't want to just say, oh yeah, there's enough there, and then have the court say, no, there isn't. Because it may be that the court wants to take some permit us to take some preliminary testimony in order to make that decision. But what I really think, instead of starting an evidentiary hearing on a motion to determine if there should be a referral, I think that there's a sufficient showing that there should be a referral by this court because of 1.7 under the court's authority under Utah Code section 17-68-304 before we even begin to take testimony. I mean, the fact that Mr. Gray is going to be the first witness we call already, and that the state hasn't moved to quash because it's a frivolous subpoena or it doesn't have, there's no basis in the factual predicate to examine Mr. Gray about these things, suggests that there's a problem here. That Mr. Gray's office is representing Mr. Gray while also trying to represent the state. And that's an inherent problem. And I understand it's a thorny question. It's what's the showing that's necessary, and does the court have discretion, or is the court compelled to? Is the court going to commit error if it doesn't? That's why I think that maybe some thoughtful briefing is an appropriate thing to do before we start an evidentiary hearing and then realize that we got off on the wrong foot, because there should be somebody else seated at counsel table when two members of the state's attorney's office who are members of the prosecution team are two of the 4 or 5 witnesses in this hearing. So I'm not trying to dance around the court's question. What I'm really saying is,
Why are
I
your
don't
feet
know that we
tapping
can be
so fast?
stuck with only being able to give a court a showing based on the evidence we've been given, when all we've been given is a memo that says, this person was there, we don't think it's a problem. They were 85 feet away when Mr. Kirk was killed.
And so, and I appreciate what you're saying, counsel, but what I'm trying to determine is, in your regard, in your understanding, I want to address this, the sufficiency of the showing. Is it your request for an evidentiary hearing for you to present to the court enough evidence for the court to make that determination, or something else?
If the court doesn't believe that the papers themselves sufficiently demonstrate that for purposes of the motion to disqualify,
If I'm going to lose, then do it the other way.
state should be represented by somebody else, then the answer is yes. We want to have an evidentiary hearing up until the point where the court reaches that conclusion. Because that would be the only way for us to satisfy whatever showing the court deems necessary. So we're not going to waive an evidentiary hearing if the court's saying, well, I don't think we have enough evidence here. Obviously, the answer is yes. What I'm really just saying is, I think that based on the papers, the court can say, yeah, this is a significant problem in a serious case that has really, really serious consequences for Mr. Robinson, for the people of the state of Utah, for the victim's family, and we should do this carefully and correctly. And I think the way to do that is to have the Attorney General of Utah designate somebody in their office to represent the county for this limited purpose until the court determines the scope of the conflict. We think the conflict requires disqualification from the case, but ultimately, obviously, that's going to be a judicial determination.
All right. Anything further
that's what
from
I
the
heard
state before
too.
the court makes this ruling on this
I've been
issue?
hearing all this.
I just want to clarify, you're talking about the need for an evidentiary hearing in order to determine whether or not that the county attorney's office can handle the motion to disqualify?
No, I'm determining just an initial showing of a conflict that exists here. Like
Well, for what purpose? To disqualify the office, or to have the attorney general's office step in and handle the disqualification motion?
to disqualify the office.
Can I take a crack at it?
If you wouldn't mind, Mr. Gray, just stepping to the lectern, just so the record picks you up. Sometimes these microphones are a little long.
If I could take a crack at it. Basically, I think what you're saying is kind of like a Frank's hearing where you have to allege sufficient facts so that based on those facts, if the court takes that as true, then you would need whether or not there would be a legal basis to conflict it out or find a conflict, right? And so if they don't make that showing, then the court can rule straightway. But if they do make that showing, if what's alleged is true, then we go to an evidentiary hearing. Is that?
Mostly, it's the initial showing of a conflict, and what happens after that will be determined, because they're bringing this up for the first time today.
Basically, like a prima facie showing initially. Is that what you're saying?
Essentially.
Yeah. Okay. I think that's. Yeah. I'll let you.
No, I appreciate your clarification. Mr. McBride.
Nothing else.
All right, it's the court's, and I've read the briefing by all parties and listened to the argument today, and I don't believe a sufficient showing has been made for the court just relying upon the briefing itself. And so I can't make that finding based off, well, I would find that that threshold showing hasn't been met based off the briefing. And turning to Mr. Novak, based off that finding of the court, what is your position?
He's going to argue with it. I want evidence. I want to fish so I can show you there's more here than just what we have in our brief, even though I don't know if there is or not. That's why I need to have this evidentiary hearing so I can fish.
Our view is that if the court has concluded that the briefing does not yet rise to the level of proof that the court should at this time make a referral, then the court should begin to take evidence. And there may be a moment where the court says, okay, I've heard enough. Now I'm ready to make a referral. And we're going to stop and pause, wait for the Attorney General to engage. And then we'll have to see where that goes. But it may be that we have to finish the evidentiary hearing. But, and I think all of us can attempt to prioritize the portions of our examination so that the court can make that finding as early as possible. I'm just trying to avoid doing the hearing twice.
I understand.
Because right now, it's our view, the state is not being represented by the attorneys who should be representing it. And so if the state's going to come in later and say, well, we want to redo the evidentiary hearing because the state wasn't represented by the right parties, I mean, or by the right lawyers, that's something that we would want to avoid. We want to do this once out of a courtesy to the court and to a couple of the witnesses.
No, I appreciate that. And can this be accomplished by proffer?
I don't know what the witnesses are going to say because they've only given us very limited information. The state elected to give us information in their briefing, some of which is, like I said a few times now, is not sworn by affidavit or declaration. It's in the nature of argument. I mean, there are portions of Mr. Gray's brief, he signed it, where he makes many, many assertions of fact in the course of arguing the legal issues. And none of that is sworn. And I mean, I'm sure that, and I think, so I don't think there can be a proffer because I don't know what the proffer is.
Mm-hmm. That's
I
your
know
problem.
that I have a lot of questions
Right
about things that that the court was not told about in the briefing and the affidavits. So the answer respectfully is no, it can't be done by proffer.
All right. And which witnesses are you intending to call today? Now, I understand you're saying you wish to just put on enough and focus on the key issues, but just if I were to grant, I'm just trying to understand the scope.
Well, I think Mr. Gray is the first witness. The second witness.
Your Honor, if I may approach.
Yes. Parties to the bench, please.
Okay.
We'll chat at sidebar. Oh man. So the judge is clearly signposting throughout this whole thing that he doesn't think if he takes the facts as the defense has alleged them, that there's a problem here. And I can't take issue with that. The person is unlikely to be a witness. And even if they were, they're not material. It doesn't meet the standard. And so he's basically trying to get the parties on record. How much am I required to let you fish before I make the decision about whether there's a conflict or not? And the state here had an opportunity, and they got so close with Mr. Gray comparing it to the Franks hearing, because that really is what he's saying. He's saying that the defense has the initial burden to come up with something that shows this is even like a serious consideration, a serious chance of meeting the standard. And they haven't done that. Like this mere fact in and of itself doesn't meet that. And so the defense keeps coming back to, well, that's why we have to have the evidentiary hearing.
Thank you,
because
counsel.
They don't know
In regards
what
to
they
the
don't
question
know.
of what witnesses do you anticipate calling?
Mr. Gray, I'm going to get his title wrong, but Mr. Christensen is an investigator with the county attorney's office. The prosecutor, who we believe is conflicted off, and their offspring.
All
Offspring.
right. Any input from the state at this point?
No.
All right. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
Is the court looking over my shoulder at
No, I'm
media
looking at
counsel?
no, you.
Okay.
Sorry, there is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
When the county attorneys have informed us of this factual issue, and we told them that we thought that there was a disqualifying conflict, we had an agreement that we would file our motion privately, I think is the correct term,
Sure.
so that certain identities were protected. And that was at the request, and we've continued to accommodate that, and we have no problem with that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, and Mr. McBride has verbalized this very well in conversations among counsel. The record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super, super awkward. And so that's why we are fine with the hearing being closed, which I think it's fair to say we view as an appropriate deference to the requests of the county attorneys.
All right. To the state.
Given the extreme publicity and the issues that surround this case, we would ask that this portion of the hearing be closed. We've had communications with counsel for the media. We believe that they agree to that after taking a balancing test of the public's right to know and the right to an open proceeding and the privacy interests at issue.
All right. One of my concerns that I have, and is there any other parties weighing in?
I think there may be, Your Honor, both
Your Honor.
WebEx and here in person.
All right. Well,
Your Honor, this is Jeff Hunt. Can you hear me?
I sure can, Mr. Hunt. Thank you.
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague, David Ryman. We represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay.
All right. I'll hear from you.
We did meet and confer with counsel for the state and counsel for the defendant concerning closure. And counsel has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court without causing prejudice to the privacy and personal safety interests of the family member witness involved. They've told us they believe it would not be feasible or practicable to approach this on a witness by witness basis or an issue by issue basis because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses. So we have no reason to doubt the statements and representations of counsel, and in reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness by witness or an issue by issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing and make limited and appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases, just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They can be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps. And any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, but that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
Your Honor, as to the oral argument, it is our request that it be closed, and the reason why is that we're not perfect. Names slip. It's happened in trials. It's happened in arguments before, and I'm concerned of the risk that could have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said, a fallback position could be not live streaming the event and requiring any redaction should an inadvertent mention of a name be made.
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order. And I will have to cite to the relevant facts. And quite honestly, the name of the prosecutor is a relevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address and which has been brought up in briefing. And so this court is going to deny the request to close the hearing as it relates to, and I will take this motion witness by witness. I understand that there may be a witness that this is applicable to, and the court will entertain that. But because this court has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present. And if you're talking about a name that needs to be protected, that's on you on how you speak. I can't. It seems inappropriate to create a safeguard to prevent you from making a mistake on accidentally saying a name. That I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as reason to close the entire proceedings for the evidentiary hearing portion. But
Wow.
again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as we go.
Wow.
Mr. Novak,
Yes, Your Honor.
with that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
I just want to clarify. Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Okay, thank you.
May we have a moment?
Yes.
They're going to close for the child and not for anybody else. That's going to be my guess. I love this, okay? Because my first beef already with what the media was saying is that the whole questioning about the decision-making process for the death penalty is exactly the kind of thing that there is an extremely high First Amendment public interest in understanding that, in being able to see the public's elected representative who makes this choice on behalf of the public explaining his reasoning. And doing that behind closed doors where we don't get to see that is just, that's so antithetical to our participatory government. I can understand very, very well the concerns that they have about there's loonies out there and there are safety considerations if people's identities are out there. And we already know this is an 18-year-old child back in September. So young adult, just child, meaning, relationship wise. This is a young person, didn't ask to be in this position, didn't ask to have this relationship. And I can understand that person not wanting to be on a national radar and some protections being put in place to try to prevent that.
Oh, looks like I'm off. Would it be easier just to go into a brief recess? I don't want to make you feel rushed. You have obviously important conversations. So it's the court's intent to enter a brief recess to allow the parties sufficient time to discuss whatever you need to discuss.
Your Honor, I think I'm comfortable moving forward, making a offer right now, and asking you to reconsider that motion. And the reason is because courts, the Supreme Court of Utah, appellate courts refer to witnesses by their initials all the time. In our pleadings, we often refer to witnesses by their initials. In Supreme Court of the United States opinions, witnesses are referred to by their initials. And that's because there's a privacy interest. In this case, I don't think a privacy interest could be greater. This case has polarized the nation in many ways. And there have been death threats made against other witnesses. There have been death threats made. My understanding is there's been threats against counsel. Our office has received threats. Doxing is a real thing. Finding people online, harassing them online. With the technology that we have now, it's not that hard to find out just about every detail about a person through internet searches, paid subscriptions to programs that do background checks. And we are extremely concerned that we will have a person that does not need to be subject to death threats, to harassment, to doxing, to all of those things that can be avoided. We're very concerned that will happen and happen to this person for no other reason than this person's father is a prosecutor on the case. Your Honor, I think that there's a way around this, that we can avoid those threats to her, those risks to her. And I think it's by referring to substitute names like we have in the public pleading. So, Your Honor, I would just really ask you to please reconsider your opinion. There's a stipulation from the media to shut this portion of the hearing. There's stipulation from the defense. I think the court in its ruling can refer to the prosecutor as the prosecutor. I think it can refer to the child as adult child. I think that would be adequate. I think in a sealed record, there can be references to names. That would be my request, Your Honor. I can't ask more adamantly than I am now.
To defense.
We take no issue with anything that counsel has said. That's why we completely deferred to the the county attorney's initial request that all of the briefing, as much as possible, be under seal and then redacted.
Thank you. One of the points that when I was considering this as a potential issue is that both parties filed a public version of your motions, and you used a mechanism to convey that same information. And then I understand that that makes it tricky, but it was the choice of the parties to do that, to publish those public versions. And the court is fine in regards to particular witnesses referring to those terms that were used in the motions, but this court does not agree that the entirety of the evidentiary hearing needs to be closed. And it is a very broad approach to a narrow issue. And I understand and I respect the concerns made by Mr. McBride, and I understand that, and the court is willing to go witness by witness. If you feel that a particular witness that needs to be closed, the court will entertain that. I understand the issues of safety, and the court feels the urgency and the importance of that has been stated, but this court cannot find that the closure of the entirety of the evidentiary hearing is proper, given the motions that have been filed publicly online. And I have to leave it to counsel in deciding how you present the evidence, how you state the names. I'm willing to abide by the format used in those public motions, but this court denies the request to close the evidentiary hearing. And again, we'll take witness by witness a motion if that particular witness needs closure that particular witness's examination needs to be closed.
He's gonna close the child and nobody else. He's basically told you. You already know.
If the court's ready to begin the evidentiary hearing, we would call Jeffrey S. Gray as the first witness.
All right.
Or if the court wants to take a little break, we can do that too.
The courts can move forward. If parties need a break, I'm happy to give a break. I know we're switching gears here. Yeah, go ahead. In fact, let's go ahead and take a brief break. We need to relocate our court reporter, so this is a natural spot to take a break.
Can we have one moment of sidebar?
Absolutely.
Oh, sidebar and then recess.
Hold on, counsel.
I'm going to just mute it because it doesn't seem like anything is going to happen, but I guess we'll see. Oh my gosh. This judge. So he's already being kind of generous, in my view, letting them have this evidentiary hearing at all, because what he was clearly saying at the outset was, defense, your facts that you've alleged don't meet the threshold for me to be concerned about a conflict of interest issue here. The Gray's comparison to the Franks hearing, I think, was a good one, where you have to present some kind of facts for there to create an inference that there was false information provided in a warrant affidavit. And yes, it might be hard to get those facts, but that's your job as the defense attorney if you're going to make that type of a challenge. And so only if you meet that initial threshold showing do you get to have an evidentiary hearing where you get to flesh it out in a little bit more detail. The practical reality of the situation is that the evidentiary hearing just ends up being the prosecutor and the law enforcement witnesses and whoever offering their excuses and their explanations for why they included misleading information in the warrant affidavit. But be that as it may, I would expect a similar type of situation here. The defense wants to fish because they don't know what they don't know. And so they want an opportunity to get information that they aren't otherwise entitled to. I'm seeing if they're going to say anything else. They don't know if there were any other conversations about what apparently we know now it's a daughter. You might as well just say it's a daughter. What the daughter saw. So they want to be able to ask about that. They want to be able to ask about what conversations the prosecutors were having amongst themselves about this incident and about their decisions and you know the communication, all that stuff. They're not really entitled to know that. So he's being quite generous already, I think, in allowing them to have this evidentiary hearing at all, because he has clearly indicated he doesn't think they've met the threshold. If he just goes off of what they've alleged, the fact that the family member was present with 3,000 other people and didn't see anything extraordinary and provided the information at the time, he does not think that that meets the Rule 1.7 standard. We can look at that, by the way, at some point if we want to do that, maybe when they for sure go to recess. So, you know, the media. So then we're talking about closure and everybody, even the freaking media. Okay, this is why the media sucks. This is like one reason why the media sucks so bad. They're such a bad representative of the public.
The court is back in session. Counsel?
I believe the exclusionary rule is being invoked.
Yes, Your Honor, we'd ask the court to exclude all witnesses during the testimony of other witnesses.
All right, and to the state, any input?
We agree.
And at this time, would it be convenient to just take a brief recess?
Yes, please.
All right, it's 3:20. How about we come back at 3:30 and resume on the record?
Sounds good.
All right, court is in recess.
All right, 10 minutes. They're going to take 10 minutes here. So, yeah, okay, let's have us a little media rant, should we? Because their remedy for like, I can't control my tongue, I can't maybe not accidentally slip, is that we, the public, shouldn't get to be able to see anything, including testimony about the decision-making process for pursuing the death penalty on our behalf and in our names as our representatives. This is just dumbfounding to me that this would not be seen as one of the most important decisions a elected representative can make for the people that they represent, is when the state should take somebody else's life. It is the most serious decision a government can ever make. And they're going to testify about that. And that should be all behind closed doors, because you can't be trusted to not slip and say her and make it really clear when you've already told us it's a child of a prosecutor and now we know it's a girl child. And you've already told us it's a supervising deputy. Like, I'm sure people can figure this out and put the pieces together. And so the judge, you know, throwing this back on the parties that, look, you guys filed this in public. You set the ground rules. You're the ones who figured out that you could file this public version that's redacted, that figures out ways of concealing the bits that need to be concealed, but lets the rest of it be out there in the world where it should be, where we can all see it and evaluate it. Because, yeah, everyone who is interested in this case is going to take an interest in a decision to potentially boot these prosecutors or not, and what that's based on. It's a pretty important decision that's being made. And so the suggestion that that should all be behind closed doors, oh my Lord, I have to give the judge such major props here. And frankly, I don't even care if it's kind of self-centered in some ways, like, because it would come back on him. His court being a secret court, his ruling being based on who knows what, whatever we didn't get to see. Oh, we get to eventually read it in a redacted transcript, but we don't get to see how people present. We don't get to hear the tones. No, like major, major props to this judge. And so pointing out, look, he's got to make findings on this, and he does. If the defense is arguing there's a disqualifiable conflict based on the facts, he's got to find what the facts are in order to reach a conclusion about whether there's a conflict or not. And he is already giving them so much freaking leeway to develop facts that they don't have. He is letting them go fishing today. He's letting them go fishing. I don't know why the prosecution agreed to that, frankly, but I don't know. He's letting them go fishing. And so the media this should just be a limited exception, but you know, understand, we can't take issue with their judgment that there's nothing less restrictive than completely closing the entire hearing that could make sure these privacy and safety interests are protected. That's the media's position. And I gotta think about why that is, right? Because the media likes to get real high on themselves, pat themselves on the back real hard about how ethical and responsible they are. All those things. They have the journalistic standards, you see. And so the problem is, you know, all those YouTubers, podcasters. Where have we heard this before? You know, it's that bloodlust that old Judge Diener was talking about back in Richard Allen's safekeeping order. I mean, is that what's behind? Maybe I'm taking it a little far, but this is what I hear behind the media's, oh yeah, no problem, go ahead and close it, as representatives of the freaking public. Because those people out there who don't have their standards and their ethical responsibilities and so forth, they can't be trusted the way that we can. Oh, please. Thank you, Judge, for seeing through this. We have a right to know. So he's going to take it witness by witness. And as far as I'm concerned, like, you might as well you can go ahead and come out and say, because we can read between the lines here. We've read between the lines so far all day, I think pretty well. You're going to go ahead and close the daughter. Everybody else is going to have to testify in public. And that's how it should be. I mean, I don't really take issue with that. I really don't. I'd prefer that the daughter be in public and they not show her. You know, they have done this. Courts have dealt with this for a long time. This is not the first time this has ever come up. They have figured out ways to handle this, where witnesses testify from behind a screen, or witnesses testify from an adjoining room over a video feed. You know, ways that the witness is not visually apparent, but is still present in court and able to testify. And so for all intents and purposes, we get an audio. That can be done. And I don't know that there would be any feasible argument here that, like, hearing the voice of the witness is somehow going to tell us more identifying information than what you have already told us with your own words. that it's somehow going to be easier to figure out who this person is even if people in court are able to see who this person is and we at home are not, but we're able to hear. But the prosecutor needs to be on the stand. The prosecutor with the alleged conflict, if they're going to let him do this fishing expedition, I think the judge would be perfectly justified in not having the hearing at all. But he's being cautious and he's giving them every benefit, and I'm not going to disagree with that either. I think he's being extremely generous to the defense with that. And yeah, in part that's because it's a death penalty case and he wants it to be clear that the process is as fair as it could possibly be. He is bending over backwards to be extra fair by letting them have this hearing at all. So just in case they can come up with something through their questioning that they didn't already know, they can chum these witnesses, see if they get a little something that they can haul in and capitalize on. That's being extremely fair because he doesn't have to give them that opportunity. But if it's there, then it's better that they find it out now, rather than potentially it come up later. So, but the prosecutor needs to be on the stand. That prosecutor is acting as a representative of the people. And even if he's not the elected, he's an agent of the elected. He's somebody that the elected is entrusting to handle this prosecution and to make decisions about it. So we should be able to assess that as part of our assessing what do we think of this elected official's performance and their decision-making and their ethics? Are they making good judgment calls here? Oh man, what a change of pace. What a change of pace from a judge. Every single person was like, yeah, go ahead and close it. And he's like, yeah, no, I won't be doing that. Oh my Lord. I'm dumbfounded. This is so not what you expect to see. Because there's everybody's in agreement. There's nobody to take issue with his decision except all of us who are powerless in the process. We have no standing, no ability to do anything at all except just voice our discontent with him going along with the parties. And he's taking that into consideration. He's caring about us. Like, what world am I in? Wild. Oh man. So yeah, they're gonna call Jeff Gray the elected. We're gonna start with him. Yeah, I think we're gonna get to see that. I don't think the judge is gonna close that. He'll take it bit by bit, witness by witness. He's not gonna close off the elected prosecutor. This is kind of a big, important moment for the defense. This is a real, you have sold some wolf tickets here on this conflict issue. And you're going to need to show up and give the people a good show, or I just got to think there's going to be some blowback, some serious downsides to their strategy in all of this. If they go and fish and they go home with an empty bag, not from the judge. I mean, gosh, I'm such a fan of this judge right now. I mean, I've had like a couple concerns so far in the case. But by and large, he seemed pretty good. Today is like next level. Next level. This might be like my favorite judge I've ever seen. But he's not gonna hold it against the defense, at least not in any way that I think anybody would ever see. That they threw a punch that they really didn't have anything behind. But the prosecution team is going to take this real personal. They're going to take this real personal. And so if they don't come up with anything, if they do their fishing expedition and it comes up with nothing and they still lose this motion and now these prosecutors are still on the case and now they have a grudge against you because you have pushed for this process that's requiring this public hearing that is now, in their minds, putting a deputy prosecutor's daughter in danger. You think they're going to hold that against the defense team? What do you think? Uh-huh. Yeah, this is going to turn into a grudge match real fast. Real fast. This has been, from what I've been able to see so far, a very collegial type of prosecution. They have been courteous to each other. They have been, you know, they aren't aggressive in their presentations. They don't name call. They don't accuse. They don't, you know, just do the obnoxious things that litigants often do when they're adversaries and they're fighting hard and they want to win. Both of these sides so far have been pretty restrained, pretty respectful, pretty polite, pretty accommodating. That's going to change. I'm just going to call it. That's going to change. Because the defense is throwing a punch here. If it doesn't land, they are potentially going to regret that. Mavka better than Judge Penny Ascarati. I like how you spelled her name, Judge Ascarati. Yeah, I know Judge Penny got a lot of love from the public, and I certainly didn't like hate Judge Penny or anything like that. But I didn't quite love her. I think nearly as much as everyone else did. A lot of her calls I thought were just odd. The one of the big ones being like if you it wasn't what if any. God, what was it in that trial that it was Elaine's way out of leading questions? Maybe it was what if any. Now I can't remember. It's been so long. We watched so many things in the meantime. I don't know. She had this she had like her interpretation of what's a leading question that is not really leading, but then she had this like stupid magic word way of getting around it, which was ineffective, and little things like that I didn't particularly agree with. I don't know. She was good with the cameras. Definitely got to give her that. She was good with the cameras. But she didn't do anything like this. She didn't stand up for the public over the objections of the parties like this. She just basically, you know, did what they agreed. She was a fairly classic judge that was like, work it out between yourselves. I did not like how she handled a lot of the discovery issues that came up in that case. She handled it the way judges often do, which is basically by not handling them. And that it doesn't effectively discourage the gamesmanship and the wrongdoing if you don't hold people to account for their bad choices and you just want it to not be your problem. It is your problem. You're the judge and you have to decide it. We haven't seen any issue like that come up yet here with Judge Graf. So who knows how he's going to handle things like that, because it almost certainly will happen. Like it always does. It's inevitable. Discovery arguments are integral to court practice. Now, maybe less in criminal cases than in civil cases, just because the process is so much different. But I don't know. We're gonna see. Judge Penny wasn't too bad. She wasn't too bad at all. But I've never seen anything like this. The judge has the total out. Give the parties exactly what they want. Nobody's going to challenge him. Nobody's going to take it up on appeal. And he says, nope. Nope, I'm going to think about the public. The people that aren't there and that have no voice. I'm going to put their interests first. Like, I must be too jaded, because that's a principled judge, and I'm like, wow, what is this? What is this miracle that has appeared before us? Oh, guys, I just want to mention, I want to thank you so much, because you guys have gotten our fundraiser for Danny and Malyia. We are up to $1,733, guys. Let me share that with you. We are a little bit over halfway to the goal to get them all the way to nationals. I appreciate you and your support for them so much. I can't tell you how much these kids are worth it. Like, they are so awesome. They are such good kids. They work so hard. They are so dedicated to what they do. They are tough. They have taken their losses and they keep showing up. And it's such a good life lesson. I've said so many times, I wish I had found boxing when I was this age. When I was, Danny's been at the gym since he was like 8. To start young like that and start having those habits, and just the mindset that you develop in the ring, because you're on your own in there. It's a big team effort to get you prepared to fight, but when you're in the ring, you're on your own, and it's you and your training, your trust in your own abilities, your confidence in yourself. It's your physical and mental preparation is all you have to rely on. And it sets you up for just such a good place in life in the future. Such a good, mindset and stuff. So thank you so much for supporting them and helping them on their journey. They are super awesome kids. They are great fighters, and they have the potential to go real far. Well, while we're waiting, I'm going to go ahead and share with you real quick, for those of you that are interested. This is what, oops, where did it go? I guess I lost the screen. Here it is. This is what this whole thing is about. This is the rule. This is Idaho's rule for the conflicts of interest. And so this is what tells you if there's a concurrent conflict of interest. One client will be directly adverse to another client. That's not our situation. This is the one we're dealing with, the significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. And so that's what they're saying. The prosecutor has duties to his daughter, we know now. He's got a personal interest in his daughter's well-being, veracity, safety, etc., all of those things. And so does that relationship create a significant risk that he's not going to be a good prosecutor? And the judge is saying, I don't see it. I don't see that that we've met that threshold with what we have, because you gotta kind of anticipate, well, what would the problems be? Okay, if the allegation is The easy one is she ends up on the stand and you got to cross-examine her. You can get out of that. We already talked about that. It's unlikely she gets on the stand anyway because she's not material. But even if she was, just have another prosecutor do the cross-examination. And if there's some argument that another prosecutor wouldn't be able to effectively do that, you got to kind of have a good explanation for why that is. Prosecutors' kids do get prosecuted. It does happen. We had that come up in Walla Walla not a super long time ago. So it does happen. If it's something like he's going to make decisions about the case based on, his relationship with his daughter and what his daughter saw and stuff like that, you got to show what types of decisions would potentially be affected by whatever bias, I guess, we're imputing to him. And how is that detrimental to the interests of the people? And so there's kind of a lot that gets involved with that when you're talking about a prosecutor, because it's sometimes like it's not uncommon that I would get clients that would be like, the prosecutor is biased against me. Shouldn't we, get another prosecutor? The prosecutor, said this about me, or he prosecuted me in another case and said these bad things at sentencing, or just things like that. The prosecutor is biased against me. That's not a problem in and of itself. The prosecutor is kind of already understood to be biased against you because the prosecutor is accusing you of a crime. And as long as the prosecutor has evidence to support it that meets a probable cause threshold that, a judge or a jury, a grand jury, or whoever agrees with, then then the prosecutor having ill will towards you isn't a problem. We are going back to the hearing.
Good afternoon.
Good afternoon.
I understand there may be an issue.
There is, Your Honor. Michael Berg for Mr. Robinson. We filed today a motion to be heard in the future about excluding cameras in the courtroom. And one of the issues that's reviewed in that motion, which of course court hasn't had a chance to look at it yet, is the cameraman's repeated violation of the portion of the decorum order, which requires that the camera not focus in on Mr. Robinson's lips to allow a lip reader to translate confidential communications between counsel and Mr. Robinson. And that order has been violated in the past. It's been used by the media to interpret falsely the content of conversations between Mr. Robinson and his lawyers. And it happened again just while the court was in session. I have the clip, and I'd like the court to look at it to see if I'm correct, because I think the court will see they're zooming in on Mr. Robinson's lips, and it's going to allow the media to offer these same sort of false narratives they have in the past. So with the court's permission, I'd like to present that to the court.
Well, Mr. Burt, this is the violation, or is there anything else? I want to make sure I hear your argument and view the evidence in its entirety. And so if there's anything else, I want to consider it all at the same time.
Yes, and for purposes of the motion I'm going to make to the court now, which is to either exclude the camera for purposes of this hearing, and of course the court will take up the issue with regard to future appearances when the court considers the motion, or in the alternative, to order the cameraman not to focus at all on Mr. Robinson. And so I think for the purposes of that motion, the court needs just to look at the clip that we would proffer to the court as showing that there was a clear violation of the court's order.
Thank you, counsel. I appreciate that. Before I turn to that, I'll turn to the state if they wish to weigh in the request.
I think it raises a legitimate concern. I think the court ought to consider the evidence that the defense counsel has.
All right.
It's very brief.
I appreciate
we have it on a phone and the court can look at it.
And have you shown that to
I have.
the other parties?
I have.
Okay, thank you. I appreciate that. All right. You may approach, yes.
I missed it, but I see a lot of you in the chat saw it. I mean, we knew it's, they just can't not. They can't not get that money shot, right? They just think
What
that's
is the
so
length
valuable.
of the first video?
9 seconds.
And do you want the benefit of the record to articulate what this first clip shows?
You know, I think the clip shows that the camera is zooming in the first clip on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video here.
Yes.
So twice.
This one is 5 seconds.
Yep, it's 1,000,000 times this. It has nothing to do with the public's rights.
That looks like.
So they can sell ad space.
And Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nestor. And Your Honor, one last thing I'd like to add if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order. And I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
He's not wrong about that.
Thank you, Mr. Burke.
Thank you.
Yes, they sure did.
Just one more question. I apologize. Just for the benefit of the record, from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor, I forget the paragraph, but there is a paragraph in the court's latest December 23rd decorum order.
It's
I think
paragraph 48.
48. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and then there was a second one referring to, and I want to make sure I wrote it down right, because
Sure.
Something along the lines of not showing Mr. Robinson at all. Like, I want to make sure I understood that request.
Sure. The request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation and because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson, that the camera should be focused on the court and the witnesses if the court permits that, but it should not be zooming in on Mr. Robinson. His demeanor, his conversations with his lawyers have nothing to do with the newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters. And it's creating massive prejudicial publicity for us. So that's the request.
Thank you, Mr. Burks.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities. I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. It's the second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel. at council tables or bench conferences with the judge. The zoom in language that you have heard referred to previously doesn't fall in that sentence. The zoom in language comes in the next sentence, which says no one may zoom in on anything on council's table or the bench to identify any writings. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order, that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision, of defense's concern about the potential violation of that order, and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that, and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. Well, before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
Your Honor, we have nothing to add. We'll submit the issue.
All right, Mr. Burns.
Judge, the problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was a same violation. Lip reader. I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted.
What? What? Did they just kill our feed? What just happened? Did the cameraman make a run for it? I mean, I'm going to assume that's the whole feed and it's not just KSL, but I will go check. Nope, it looks like it might just be KSL. Let me go ahead and go over here.
The decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about
already heard.
Here's that
They're just on a lag.
Do not believe that any further reprimand or any sort of
Okay,
further
hang on.
exclusion is necessary here.
Thank you.
Let me get out of here.
Well, before I turn to you, I want to turn to the state.
Let me get out of here because I think we have the original feedback now. I knew I shouldn't have messed with it. It's how it always happens. No, it's dark and there's no sound. Stream loading. Did they put us on a delay maybe? I don't know. I'm going to back up and kind of see what happened. Bert came back up. Things went wacky. They stayed wacky. Yeah. I don't know. Science and Southside, just checked Court TV, and Court TV seems to be on a lag. I think the reason why it looked like it was live on Court TV is because they were behind. They were still at the point where let's see. Yeah, see, I think they're just behind. I don't know. Someone's saying East Idaho News. Let's check. Oh, are they back? I don't have it muted.
2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney and Mr. Robinson speaking for about 9 seconds is what my memory showed, tells me and reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. And in both instances, I could see Mr. Robinson's lips moving. And I don't remember about the second clip, but I believe in the first clip, it also showed counsel's lips moving. But notwithstanding, that was in place. I also refer to the statement made by the counsel for the news media, and going to, it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's table or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Now, in regards to the zooming, I know there was a representation, and it's easy to, as you're reading, to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons. And so I find that the decorum order, as it relates to paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that has been violated. In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel, that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader. Turning to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations, I turn to the sanctions. Previously, I stated that under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. I find that applying this sanction would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not. I find that the court will not issue this sanction. In addition, the other sanctions the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. Immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing. And so the court considered that as well. This court does not wish to make a disproportionate decision on the actions, and it does note and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of this hearing, that the camera shall not photograph Mr. Robinson at all. And that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that. Well, first, sir, I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. Again. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply. And I recognize that it wasn't your anticipation to be on your own camera, but as it relates to not showing shots of Mr. Robinson for the remainder of this hearing, what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time.
You can't see the witness stand.
That.
You'd think he'd want that.
Again, I don't want to set you up for failure given what's happened. And so what are your thoughts?
I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right.
Because we really need to see that messy bailiff.
Thank you.
station
All
there
right,
instead of the
turning to
witness.
the parties, any clarification needed about the order of this court and the sanction that is imposed?
Your Honor, I only have one. It sounds like this issue is specific to video coverage and that the order not to take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that issue?
Just to indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor. So if they catch him in a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence that he's some sort of a remorseless killer. So that applies to the still photography as much as what's going on with the video. So we'd ask the court not to permit still photography, at least for purposes of today. And I think after the court sees the motion, we'd be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Burt.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs? All right. This court narrowly tailors its decision as to the violation, and the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is, and this moment is eluding me, but the person who's operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with a 9-second clip and a 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the pool camera photographer, again, recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and the seriousness and professionalism that you presented this to the court. So thank you to all parties. And again, to the camera operator, do you need time to test out to ensure that there is any inadvertent capturing? I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing.
Understood, Your Honor.
All right. All right, counsel. With that in mind, how would we like to proceed?
Guess we're going to watch Mr. Gray from way over here in the back. We're in the nosebleed
Ask
seats.
the court to swear in Mr. Gray.
Mr. Gray, if you would approach and stand before the court clerk to be sworn in.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Mr. Gray, if you'd like, have a seat. Usually we have water bottles. If not, there's one right here. All right.
Now we go on
Mr.
Ultra
Gray, I'm
Zoom.
sure you've heard this before, but if you could position the microphones close to you, just to ensure that the record picks up your testimony today.
He told you, cameraman. He told you to
May I
move.
proceed?
Yes.
Thank you. Mr. Gray, how long have you been associated with the Utah County State Attorney's Office?
3 years.
Okay, and it was 3 years ago that you were elected to be the chief prosecutor of that office?
Yes.
All right. And had you ever previously been associated with the Utah County Prosecutor's Office in any other capacity?
I've defended on criminal appeals. I was a criminal appeals attorney for the state of Utah for 23 years. So I represented the state of Utah on those criminal appeals, which would include Utah County.
Okay. And did you ever have any professional relationship with the Utah County Attorney's Office in any other capacity other than the appellate work you did before you were elected?
Not to my recollection, no.
Because we're in an open session and based on some of the guidance from the court, I'm going to ask you questions. Well, let me back up. How many prosecutors are in your office right now?
Well, that are with our courts, they're actively engaged in our court system is 30, and then we have screening prosecutors as well, and that would be another 7 or 8.
Okay, so I'm going to try to.
I should stop because I also, my executive team, they don't have courts, so there's another 5 of them as well.
Okay, so let me ask a better question. How many prosecutors in your office represent the state in felony matters?
Well, all of them that I just described.
30?
I mean, even the screeners. Yes, the screeners, my executive team, they are assigned to special cases. Usually my executive team, for example, aggravated murder cases, some homicide cases. So they also are prosecuting and represent the state in trials.
Can you explain what you mean by the executive team?
The executive team would include obviously myself. I have 2 chief deputies, 1 chief deputy, another chief deputy's general counsel, and then I have a division chief over major crimes and a division chief over general crimes.
So is it fair to say that there are at least 24 prosecutors in your office who have substantial experience prosecuting serious offenses?
24. I don't know that I'd go as far as 24.
Okay.
Certainly all my SVU attorneys have that experience. Most of my violent felony attorneys have that experience too, but not all.
Okay. And do you know how many attorneys in your office have actually participated in homicide litigation?
I don't know the exact number, but I would say maybe 15.
Okay.
But I guess I should clarify, not all of them have the experience in aggravated murder cases. And that's why we specially assign those attorneys.
Understood. And how many do you believe have experience in aggravated homicide cases?
Probably 7 or 8.
And are all 7 or 8 assigned to this case?
No.
Are the 5 other than you who are assigned to this case experienced in aggravated felony cases?
4, well, either 3 or 4.
Of the 5?
Yeah.
Okay. All right, now I'm going to ask you some questions about a specific member of your office. And because the court may or may not ultimately order that attorney's identity remain sealed, you know what I mean by the word sealed, right?
Yes.
I'm going to refer to that person as Prosecutor A, okay? You all right with that?
Sure.
Okay.
Prosecutor A.
So how long have you known Prosecutor A?
About 3 years.
In your work as appellate counsel for the state, did you have any contact with Prosecutor A?
I may have. I don't recall. We generally send something out to, when we get an appeal, we generally send the AG's office, we send something out to the prosecutor, ask them to fill out anything that we should know. More often than not, they never send us anything. And because it's an appeal, I mean, we're bound by the record. So there's not usually an occasion, but sometimes there is. But I couldn't say for sure that I've never talked. I certainly don't remember ever talking to him, though I could have.
Okay, is Prosecutor A member of your executive team?
Yes,
And did you select Prosecutor A to be a member of your executive team?
yes,
And that was at the beginning of your
yes,
tenure as the Utah County Attorney?
yes,
And so you've had close working contact with Prosecutor A, who's a member of your executive team for the past 3 years.
yes,
And that, unless you're out of the office traveling or on vacation, that's basically every work day of the month, correct?
yes.
All right. And have you met members of Prosecutor A's family? Ever? Let's just start with ever.
What's that?
Ever. Have you ever met members of Prosecutor A's family?
I have met his wife.
Okay.
I don't know if I've met his kids. I may have in passing, but I don't really, if I did, it was like at a function, they say, this is my family and introduce me, but I don't remember.
Have you socialized with Prosecutor A and his wife?
I think we went out to dinner once after a conference in St. George with some other prosecutors and their wives.
Okay. Have you ever been to Prosecutor A's home?
No.
Has Prosecutor A ever been to your home?
No.
You engage in recreational activities in any way with Prosecutor A?
No.
Whatever you do, running, pickleball?
No.
Don't play
need to
cripple
do
ball?
running, but unfortunately I don't.
All right, understood. Okay, now, Prosecutor A has an adult child who was at the September 10th rally at Utah Valley University, correct?
That is what I mean, I don't have personal knowledge of that other than what they have told me. So like, I never saw that adult child, but I'm assuming, yes, that's true.
Okay, but on September 10th, 2025, at the moment that Mr. Kirk was shot and ultimately died from that shooting at Utah Valley University, you were in Davis County, right?
Yes, I indicated in the motion that it was Ogden, but it was actually Layton. So it was Layton.
Layton.
Yes.
Okay.
And I think that's Davis County.
All right. That's what I thought. And Prosecutor A was with you?
Yes.
Okay. And isn't it true that while you and Prosecutor A were in Davis County, you learned from Prosecutor A that one of his adult children was at the rally and was texting him about their experience?
Yes. I mean, we had just broken for lunch and he showed me the text, Charlie Kirk got shot.
And that was a text that he showed you was from one of his children, right?
Yes.
And you knew at the time that it was a text from one of his children, right?
Yes.
What did he say to you? So I'm talking about Prosecutor A.
He said, look at my daughter, look at what my child just showed me. And that's about it. And then he said, you know, I should be getting down to UVU.
Okay. And then he left.
Yes.
And he, as far as you understand, he drove down to UVU.
Well, he drove towards UVU. Yeah. He drove in the area.
Okay.
Ultimately, I met him and then we drove together to UVU.
Okay. So you, according to the pleading that you authored the pleading that was filed.
Yes, I did.
Okay. So that, for the court's benefit, that's the state's opposition to the motion to disqualify. You
Yes.
authored that, correct?
Yes.
All right. And in it, you said that 10 to 15 minutes after Prosecutor A left the event that you were at in Davis County, you left.
Yes.
Did you also head in the direction of UVU?
Yes.
Okay. And then you and Prosecutor A met up somewhere
Yes.
and then traveled to UVU together in your vehicle or in Prosecutor A's? I guess there's a third alternative, which is you met somebody else and traveled with
No, I don't remember whose vehicle it was.
All right, did you talk to Prosecutor A?
It was my vehicle, I'm pretty sure. So,
And was that just about logistical convenience, like let's just go in one car, or was there
Yeah.
some specific reason?
yes, no, that was no other reason.
Okay. And on your way to that, what I'll call the meeting point,
Uh-huh.
did you have any conversations by telephone with Prosecutor A?
Terrible witnesses.
Well, yeah, because we needed to meet. He left. I thought I would get some lunch first before I went to the command post. I got about halfway through that and said my mind was not on it. I needed to go to there. And so then we called. I believe I called him or he called. I'm not sure who called who, but then we met. We hadn't arranged that when he left.
Understood. But did he convey to you any more information about his child's experience in those conversations?
No,
And did you inquire, like, how's your kid or anything like that?
I did not.
And so you met up and then you went to the command post, which was established near the university, correct?
It was at the university.
Okay. Was it inside one of the buildings?
What's that?
It was inside one of the academic buildings.
Yes.
And did you see Prosecutor A's child there when you were there?
No.
Were you introduced to that person?
No.
Okay. Did you have any conversations with Prosecutor A about whether they should stick around and wait?
No.
Did you?
My understanding my understanding was that everybody had left. We were told that most of the students had left. They had not, or attendees. So.
Okay, so as far as you know, Prosecutor A's adult child had left the university before you.
As far as I know, my understanding was that, most of the students had fled. At first they went into buildings or whatever, and then they made their way out.
You are aware, I'm sorry, that's not a question. Give me a second, Your Honor, if you would. Okay, so did you spend time with Prosecutor A at the command post on September 10th at UVU?
I mean, yes. I mean, we were going different places, but there would be times that we would meet up. But off and on is all I can say.
Okay. And did there come a time, either on the 10th or shortly thereafter, where he provided you with some information about how his adult child was doing, having been at the
I don't remember him ever saying anything about that. And I never asked. I probably should have. But I don't remember any conversation regarding his child.
Was there anybody else at the rally who you are friends with, or is a relative of yours, or a close coworker that you're aware of?
I know that there were some people in my LDS ward whose children were there.
Okay. And when you say some people, could you be a little more specific? Like how many different families?
Just members of the ward.
Sure, but do you know how many different families that would be?
I think I was told about 2.
Okay. And who told you that?
One of the families.
Okay, so one of the families in your ward informed you that one of their own children had been there, and then another one had been there?
And then somebody else from the ward had been there.
I see. And do you know who those people are by name? I'm not asking you their names. I just want to know if you came to learn who they are.
Yeah, I came to learn who they are. Yeah.
Okay. And are you close with those people?
I mean, we're casual friends with one of them. But I don't think I learned that until well after we had filed the information.
Understood. When did you learn that?
Sometime after. I don't know.
So the information was filed obviously in mid-September.
Just in 6 days. So.
Right. Okay. And do you know, like, if you saw the children of the families in your ward who you understood were there, if you saw them on the street, would you recognize them?
I would recognize at least one of them.
Did you ever have any conversations with them or their parents about their experience?
I tried to stay away from that, other than they told me that the one was doing just fine and the other one was shook up.
Okay. And the other one was shook up. I mean, is that the term used, or is that just your way to summarize?
That's my way of summarizing it.
What did they tell you?
Having a hard time with it or something of that nature.
I'm sorry I interrupted you. So somebody told you, somebody who you know from your ward,
Yeah.
told you that their child is their child a student at UVU?
Probably. I mean, they're young adults, so I'm assuming that. I really don't know for sure. Yeah.
And I think what you said is that they told you that their child was having a hard time with it.
What? That not their child, but the other family's
The other
child.
family's child.
Yeah.
Okay, so it was like a second-hand thing.
Yeah.
Okay. And do you know if either of those young people who were at the rally, well, I'll put it this way, do you know where they were in terms of in what I'm going to refer to as the amphitheater area?
I have no clue.
The one who was having a hard time with it,
Mhm.
did you share that information with the prosecution team?
I may have. I don't remember. I may have in passing.
Did you ever suggest to any of the law enforcement officers that that person be interviewed because they were impacted by what they experienced?
No. We don't interfere with the investigation. We try to assist, but law enforcement, they identify who they want to locate and who they need to interview, and I leave that to them.
Did the person giving you this information, so this is another adult in your ward, tell you more specifically about what their child and the other child actually saw and experienced?
No.
Okay, so you don't really know much more about where they were, what they saw. All you really know is one of them was having a hard time
Yeah.
with the experience that they had.
Yeah.
Okay. I understand you said that you don't interfere with law enforcement, but if you learn, even if it's somebody you know through your community, that somebody has suffered some emotional harm as a result of a criminal act that you are responsible for prosecuting, that's not information you would give to an investigator so that they could determine whether or not, so that they could go interview that person?
I didn't consider that as really relevant to the investigation, so no.
Feelings weren't relevant? The hell you say?
The fact that this young person was having a tough time with what they experienced is what you're saying isn't relevant? When lawyers use the word relevant, we got to.
Well, it's relevant to them. As far as relevant as to our case, I don't believe so, no.
Okay, understood. Now, there was a point in time in October, I think it was October 20th, where Prosecutor A sent Mr. Robinson's counsel an email disclosing that his adult child had been at the rally, providing us with some information.
Yes.
And so my first question is, were you part of a decision to disclose that information?
Yes.
Okay. And were you part of a decision as to how that information would be disclosed or how much information would be disclosed? Like what led to that email?
Well, there was no decision needed as to how much. The decision was to provide the information that we ultimately provided you. And that is not because we believed that there was a conflict of interest, but that was out of an abundance of caution.
I understand it's your position that you don't think that there's a conflict of interest. But I think that's clear. All right. Did the entire prosecution team, as it was constituted on October 20th, discuss this bundle of information that was being disclosed, or was it just you and Prosecutor A?
I know that me and Prosecutor A discussed it, and he may have discussed it with others. I don't believe anybody else was there.
When you discussed it?
When we discussed it, one of them may have been, or two, I don't know.
But the information that you obtained sort of if I may, in the heat of the moment back on September 10th in Davis County, that Prosecutor A's child had this experience. And the text messages that went back and forth in the family, that information was shared with the prosecution team, correct? Everybody knew eventually.
Eventually.
Sure.
I mean, yeah, eventually.
Okay, so.
I mean, I only knew the fact that she was there. At the time, I only knew that she was there and that she left. That's all I knew.
Okay, but is it fair to say that you didn't set up any, what I'm going to use a term like firewall, to keep the rest of the prosecution team isolated?
No, we already
from
know this.
information that one of their colleagues' children had this experience at UVU on September 10th?
No.
Is there a written policy in your office, either that existed when you arrived or that you've prepared since then, for how to evaluate whether one of your prosecutors needs to be screened off from a case?
You know, I'm not sure. I mean, we have those conflicts that come. I mean, the biggest thing on screening for us is if there's a potential conflict where information that the defendant has, one of our prosecutors has, because that's why you screen cases, is to make sure that shared confidences aren't also disclosed to, shared confidences with the defendant aren't shared with the prosecutor.
But you could agree with me that there are other types of conflicts that can arise other than what we might call the, privileged communication.
There may be. I mean, I think there can be. I can't think of any right now, but I think the rules are pretty clear with respect to shared confidences. You can't, screening isn't the end all of of how you treat conflicts. I mean, generally speaking, we will just conflict out to another office if we feel like we need to. One example, well, I won't go into that, but I mean, we've been threatened before and there was an investigation, and of course we conflicted it to a different prosecutor's office, because in that case we were potential targets of this individual.
Understood. Okay, so you're not sure if there's a written screening protocol, but what you're saying is when we know it when we see it.
Well,
sort of what I'm hearing you say.
Sometimes we do. Sometimes I've had attorneys that felt like they couldn't talk after they've been conflicted out to at least know the victim, but notify the victim that that we were going to switch the prosecution. But there may be, I just honestly don't know. We keep an eye on those things and rely on our attorneys to notify us when there is a conflict.
But you knew as of September 10th that Prosecutor A's daughter attended the rally, correct? Was in the crowd, correct?
Yes.
Heard a shot fired, correct?
That, at that moment, I don't know that I knew that.
Yeah, but you know it as of today.
Sure, I know
because
it
you read
now.
their affidavit,
Sure.
which says that.
Well, I knew it. I knew it once all of that information was disclosed to me.
Okay. And that they had to, with many hundreds of other people, run for cover and get out of the open space where they were, correct?
Yeah, I don't know that they had to, but that's what they did.
Well, you've seen the video of, you've probably seen many videos of that day, right?
Yes.
And weren't there law enforcement officers basically directing everybody to leave the open space so that they could?
I don't know that I remember seeing any of those videos of the students or attendees leaving. I mean, I know that they left. I know that they ran away. What we learned later is that the shooter left immediately after the shot. So,
Right, but at the time of a shooting, you don't know
sure,
how many shooters there
Absolutely.
are, if there's going to be
Absolutely.
follow-up,
right,
if there are explosive devices, like all those things, right?
sure.
Okay, so let me ask you these questions about, well, instead of giving you a headline, I'll just ask the question. Once you had all the information about Prosecutor A's child's experience, okay?
Mhm.
What they saw, what they heard, what happened to them, the fact that they were separated from their personal property, all those things, okay? What I'm hearing you say is you never really discussed that with Prosecutor A and his family.
No, I mean, I did discuss, I don't know if it was day 2 or day 3. Law enforcement was there on the day of the shooting, the next day, and I think into Thursday or Friday. I don't remember exactly which day. And at some point, I was told that Prosecutor A's child left the back there.
Okay. But if you never really talked about it with Prosecutor A, about the impact on his child and the family.
I didn't say that. Not on the day of, or, I mean, in the intervening time, he reported a couple of times that he talked to his child and said that she was doing fine. She reported to him that she was not having any issues.
Did you ever ask him, well, what about you? I mean, your kid was at this.
I didn't. Not that I recall.
Did you ever consult with anybody in the Attorney General's office concerning whether Prosecutor A's child's experience raised a potential conflict of interest for your office?
No, that's what I did for 23 years with prosecutors, is consult on that. And so I didn't feel a need to go to those folks. I mean, I know how to try to figure that out.
So when one of your responsibilities in the Attorney General's office was to consult about ethical issues?
Different matters.
Different
I mean,
matters.
It could be a variety of things.
Okay.
And I mean, if you're talking about ethical issues in particular, I don't know that the Criminal Appeals Division was the right folks to consult, but I'm not even sure of who from the Attorney General's office would. So.
Okay, but you worked in the Attorney General's office for a couple decades, right?
Yeah.
And what you're saying is that in your role as an appellate lawyer for the state, you would talk to prosecutors, I guess it's somewhat more informally, about ethical issues.
Yeah, every once in a while, yeah.
Sure. And so my question is whether you reached out to anybody in the Attorney General's office about this particular issue?
No.
Okay. Did you, and when I say you, I really mean you or anybody in your office on your behalf?
Okay.
Okay? Because you're the chief prosecutor, right?
Yeah.
So when I say you, I
Yes.
mean you
Okay,
and people who work for you. What about the Utah State Bar?
no,
I mean, they give ethics guidance to attorneys on all kinds of issues, right?
yes.
But no
No.
reach out. Other county attorneys in Utah, in other words, your colleagues who are elected chief prosecutors in their counties, did you discuss this with any of them?
No,
Are you a member of organizations of what I'll call chief prosecutors?
I'm a member of the Utah County and District Attorneys Association,
Okay.
UCDAA. I'm actually the president of that organization. I'm a member of SWAP, which is the statewide association of public attorneys and prosecutors. I'm actually the president-elect of that organization. That's a lobbying organization.
Okay. And do these associations have any mechanism for providing ethical guidance to their members?
No. I mean, when we have questions, we may shoot out an email and ask about things.
Did you do that in this
No.
situation?
I consulted no one other than my team.
Okay. I'm going to ask you 3 more categories just to be clear.
Okay.
Did you reach out to any law professors who
No,
purport to be ethics experts?
no,
Did you speak with any judicial officers
No.
about it? Court reporter, get the question and the answer. Oh, there you go.
well, I just said that I have talked to no one other than my team, so.
Okay.
How's that fishing going? Slow day? Gonna maybe try a little different bait this time? Maybe you need the salmon egg instead of the worm.
Did you ever discuss with Prosecutor A whether his child should or should not be interviewed by law enforcement?
No,
Are you aware of any?
maybe, I don't remember.
Okay, so that may be important. Do you want to take a minute to think about that?
What's that?
That may be important. Would you like to take a moment to think about it?
I don't remember. I don't think so, but I do not remember.
The brief that you filed on behalf of the state, I'm sorry, the opposition to the motion has a couple affidavits attached to it, right?
Yes,
Okay. And one of those is the affidavit of Cole Christensen,
yes,
and which for the court's benefit in the record is addendum C to the opposition. Special Agent Christensen writes in his affidavit that you and he in mid-December, so that's after the motion to disqualify was filed,
yes,
went to UVU and basically conducted some observations and measurements, right?
yeah. He was investigating that part. I did go with him because it doesn't involve trial. It's never going to come out in trial. So I did go there and assisted him. But he also had another officer there so that anything that I did could be corroborated by that officer.
Okay, but isn't it fair to say that basically what happened there is you said generally, Mr. Robinson's defense counsel have filed this motion to disqualify. I want to have some measurements done because I want to figure out what risks there were to Prosecutor A's child based on where they were and where you believe the shooter was, right?
Yeah, we have very good evidence of where the shooter was.
Okay, so I want to.
And it was based on Prosecutor A's child indicated where the location that they were, I'll use they, and based on the evidence of where the shooter was. So we wanted to confirm that. Now they didn't know where, obviously where the shooter was, but we wanted to confirm based on, we knew where the shooter was. And so we wanted to confirm that, that they weren't in the line of fire. And that was important because that's critical to the state's case, is whether or not someone's in the line of fire.
Okay, so there's a few things there I want to try to make sure I cover. And if Your Honor, if there's any point in time where the court or the staff need a break, just tell me, because I can break whenever the court needs it.
We'll be taking a break shortly, but I appreciate that. And if any of the parties do need a break, please indicate it as well. I want to be respectful to all parties.
Thank you. So the first thing I want to address, Mr. Gray, is that you knew that the defense had filed this motion to disqualify based on the relationship between Prosecutor A and somebody who was at the rally.
Yes.
And had the experiences that the court has already heard about. And so you basically went out with a law enforcement officer and you did an investigation and took a number of measurements.
He did, yes.
Okay, but at your direction, right? Because you're the one.
I asked him to do that, yes.
Okay. You say in connection with that there are some uncontested issues in this case.
Yes.
That's a term you use in your brief, right?
I'm sure that you will tell me where they're not contested, but.
Well, every issue is contested, right? I mean,
So is it, okay, go ahead.
I'm not trying to have a argument because the court reporter doesn't like
I
to
stopped,
speak over
so
each other.
I'm not.
And I'm bad at that too. And I have been for a very long time. But your measurements as documented in Mr. Christensen's affidavit, Special Agent Christensen's affidavit, are of things that you say are uncontested. But I just want to make sure.
So can I clarify that? I never said that the measurements were not contested. I said what was not contested is the fact of the things that Child A could testify to. That's what I was referring to as what's not contested. Child A, as demonstrated in the affidavit, can testify that Child A was there, that her Child A's location, and what the crowd did, what she did, and then what she ran in. That's what's uncontested.
But aren't these also uncontested things which you contested issues which you seem to suggest to the court are uncontested? And that is that the shooter was on the roof.
No, I didn't say that was uncontested. I said what she could testify to is uncontested. And if there was something different than that, that's certainly what I meant. I understand that all those other things could be contested.
Okay. You've made yourself a witness to evidence that you've used to try to advocate to the court that there's no conflict of interest, right? I mean, you basically, even though you're representing the state, you went out and you participated in a what you hope is a systematic way to measure whether Prosecutor A's daughter was in a line of sight from the place where the state alleges the shooter was, right?
Sure.
Okay.
But as far as making myself a witness, I was careful to make sure that there was Cole Christensen and then an officer from UVU. If you look at the case law says that prosecutors can participate in these interviews and so forth. What we do is make sure that someone else is there so that we don't have to testify. And the defense can't force the prosecutor to testify under those circumstances. That's the case law.
Welcome to the defense world, because that's what we routinely have to do.
Competent defense counsel have the same practice. We don't interview witnesses without investigators present.
Right. And this was no different than that.
Understood. Okay, I do want to address another aspect of this line of fire situation. Okay, so it's the state's theory of the case, if I may, that the shooter was on a rooftop, correct?
Yes.
Okay. And what's the name of the building that the state believes the shooter was on?
I don't recall.
Okay. And so these measurements that are in Special Agent Christensen's declaration, you're saying were designed to basically, if I may, I'm not trying to put words in your mouth, rule out whether the child of Prosecutor A is in some ways a victim of this incident.
Not as far as a victim. We already understood that based on where the buildings were, that the child was not in that line of fire, but we wanted to provide the measurements for this motion.
So what is the significance of the measurement? What is the significance of whether the child of Prosecutor A was or was not in a physical position where they could have been shot? What is the significance?
The aggravator, as you know, is that we're alleging that when the shooter killed Charlie Kirk,
endangered others,
placed others in grave risk of death.
And you
so anybody within that zone, if you will, was placed in grave risk of death.
Okay, and so you've now gone out and you've done these measurements from the place where you believe the shooter was, and anybody who's positioning at the rally, there's no line of sight, you're basically excluding all of those people from being among those referenced by that aggravator.
That's our understanding. We'd have a very difficult time proving that others beyond that point were also in that line of danger. I mean, we could, I guess we could make the argument, but that would be difficult to prove.
And so is it your position that because this adult child would not fall within the category of people to whom the aggravator applies, there's no other connection between those people and the prosecution?
Not the crime. I mean, again, depending on whether, again, I rely on law enforcement to provide us whether they have something helpful or not. We were able to determine based on what the prosecutor's child, there was nothing useful. There was no need to provide anything. I mean, we make those determinations when they provide it to us all the time.
Did you work with Special Agent Christensen on his declaration?
On what? No.
On his declaration?
I didn't.
Did somebody else?
Yes.
Another one of the members of your prosecution team?
Yes. That's generally the practice.
Okay. Was it Prosecutor A?
No.
Okay, now we've also, I should say, you also filed with the court addendum B to your opposition, which is the affidavit of the child of Prosecutor A, right? And this person is a young adult who is a student at the university, right, at UVU?
Yes.
Okay.
That's what I'm told.
Okay.
I have no
Did you
reason to doubt
speak with this adult child in connection with the preparation of their affidavit?
I did not.
Do you know who did?
I do.
Who was that?
It was Mr. McBride.
Okay. And do you know whether Mr. McBride consulted at all with Prosecutor A about that?
I couldn't answer that. I don't know.
Did you read the affidavit?
Of course, I wrote the opposition. I better read the affidavit.
Did you play any role in the shaping of the affidavit in any way?
No.
It was just given to you, here's the affidavit.
Well, I mean, we were aware of what the student, I'm going to call it student now.
It's fine.
We were aware with what the student had said as far as what the student was aware of. And so we obviously, as I started writing based on what my understanding of that was, and I'm sure that Mr. McBride covered those areas to make sure that we were accurate.
Are you saying that the affidavit followed from your briefing and your briefing was based on your?
No, that's not it. My briefing was based on what the information that the student provided. And so to that extent, I'm sure when Mr. McBride talked to the student, that he would cover those things.
Okay, so what I'm missing is, where did you get the information about what the student experienced if you had not seen the affidavit?
That was from the prosecutor that is the parent of that.
Okay, so Prosecutor A told you this is what happened with my kid.
Right, I mean, I think that's pretty established.
All right, Mr. Novak, this
Yes,
might
sir.
be a good time to take a brief break.
Whatever works for you.
And just not meaning to pressure you, I'm just trying to anticipate how much more time
How long is
for
this gonna
questions you have for Mr. Gray, just for housekeeping purposes.
It's 4:06 according to this monitor. Oh, that's not right. It's 5 o'clock. The monitor says it's 4:06. That must be some time zone that somebody else lives in.
Like you? Your time zone?
At least another 20 minutes.
All right.
Another
So we'll take
20
a 10 to
minutes?
15-minute break, and perhaps council can confer in regards to housekeeping, how we wish to address the remainder of the witnesses, whether in a setting today or a different setting. I'm not saying which way, but if you wouldn't mind consulting, and we can discuss that briefly when the recess is over.
That's fine. Do you want to give us some guidance on what works for the court and its staff? Because
Want to stay here till midnight?
But it is.
Right. Go ahead and discuss that, and I'll talk with staff as well. That it gives me time to speak with them, and then we can confer on
Very well.
with that. All right.
Thank you.
Court will be in a brief recess for 10 to 15 minutes.
Can we handle more of this today? He's given up. He's given up on the steelhead. Okay. He downgraded to a bass, and I think he's given up on that too. And now he's just hoping that some carp will come along and get whatever it is that he's floating out there on that hook. This is kind of aggravating because it's so just duplicative of everything we already know. It's so unfocused on just kind of anything new, really. I don't mind, and I understand his need to ask the questions about did you discuss this? What was your process for doing these steps and things like that? So I don't really take issue with that, but like a whole series of questions about who he didn't consult with. And he can just say, I didn't consult with anybody but my team, but you're still going to ask him like 6 people, 6 categories of people. And so that's a big reason of, big part of why this is taking so painfully long. Oh, well, we might be buckling in for a long evening because he's still got 20 minutes with this witness and they have 3 other witnesses still under subpoena. And the judge hasn't said we're putting a hard stop on this at any particular time. Everyone kind of want to get their blankets and their pillows out and just get yourselves good and comfortable. We might be going for a while. Not real sure. Well, I totally didn't catch the violation this time. I saw the cameraman zooming in over on Tyler multiple times, but I didn't see any point where they were talking. I saw, several of you in the chat saw that. This is the risk. This is the risky Zoom. They didn't learn last time. This is the risky Zoom. I wasn't really concerned about the judge pulling the cameras. Not after he was making his stand to keep this hearing open for our benefit. He's not going to yoink the cameras over something like that. I'm not at all surprised, of course, that all of the parties kind of seem on board with that. Maybe not the media. The media finally found some guts to argue that he shouldn't be sanctioned. So I'm not real surprised with what he decided here, that you don't focus on Tyler. And I mean, this is one of those things because there's no constitutional right to cameras in courtrooms, right? So it's pretty much up to the discretion of the judge if they're going to be there at all or not. And if they are going to be there, what are the conditions for them to be there and to remain there? And I don't take any issue at all with rules that say that are designed towards protecting the defendant's right to have a meaningful ability to confer with his lawyers. This is an important part of a hearing, especially an evidentiary hearing, that you have the opportunity to be able to talk back and forth if you need to, and to ask questions and to clarify what's happening. He's got a big team. I was going to say, I always kind of prefer, just because it's very hard to have, somebody in your ear on one side and somebody on the witness stand, and you're trying to pay attention to everything. It doesn't work well. So I would always prefer to try to just give my client a pad of paper and a pen. Here, just write everything down. And if you need to tap me and draw my attention to it, okay. But otherwise we can just talk about your stuff at recess or whatever. But he's got a whole big team. And so it makes sense that they're in a little bit of a better position to kind of live interact and stuff like that. And so, yeah, if you have a camera on you and you're worried about, this camera is going to pick up that I'm saying something, and then they're going to blast some bullshit fake confession halfway around the planet, then maybe I should just keep my mouth shut. And so then even if you have a really important question or a really important point to bring to your lawyer's attention, you're not going to do that. So I don't take any issue with rules concerning cameras in the courtroom that are, respectful of the fact that it's important for this relationship to be confidential and for there not to be intrusions into that. Same thing with like zooming in on the papers on your table and stuff like that. These are frankly fairly, normal rules. But they're not universal because this isn't a universal practice and there's no universal standard. It's just up to what the judge thinks is appropriate. And so when you have a judge like Judge Bev, who doesn't really care about the defendant's rights and the counsel and so forth, then fine, they'll blast the conversations all over the TV, all over the internet. Don't have any particular restrictions on that. And so then it ends up on the parties to kind of figure out for themselves, how can we sit so we can block the camera? Do we have to do stuff like this? And the risk is in the meantime, Court TV is hiring Jim Carbaugh for their court commentary, to be watching the court feed and tell us, ooh, here's what the defense is going to do next. So I think I don't have any issue with this particular limitation. I think it's appropriate for him to draw that line. But I just also appreciate his way of handling this so far. The cameraman has gotten a public shaming. Okay, he got called out. He got put on the spot right up front. Like, you have a responsibility. And we want to make sure you understand what it is and that you can meet it. And you're saying that it is. And so when you don't, you might need to take a little accountability for that. But I also appreciate that, he's not punishing all of us because of what this cameraman is doing. And, he's not being over the top. I mean, this is a situation where, like, was it willful? Was it inadvertent? I mean, the problem is, like the defense said, they're just going to say that every single time. Oops, we didn't mean to. Like, how many oopses do you have before your oopses are starting to look a little convenient, a little opportunistic, a little self-serving? But I mean, bottom line is they should freaking know by now. If you're going to zoom in on, he starts talking, you need to get off him. You need to get off him. They need to make that clear. Like, I don't know why this is so difficult for them to figure out rules of the road. Somebody had a question earlier I saw about who was the news agency on this request in order for electronic media coverage, who brought the cameraman in. And so I will share with you guys that this is Fox 13 News. KSTU Fox 13 is the news organization that filed this request and was granted it. So they are, as far as I know, the ones that are the operators of the pool camera. So if you have anything you'd like to say to them about maybe let's not jeopardize everybody's right to see what's going on here. Maybe take your responsibilities a little bit more seriously. That is who to direct that towards. So just, yet another calm. This judge, like, I'm starting to wonder now what it would take to get under this judge's skin. Is anybody kind of like wondering what's the threshold? I mean, he was as excited, I think, as we've ever seen him today when he was standing up for us, right? When he's like, I'm not going to close this whole hearing. You guys filed these public motions, and I'm not going to make it the entire public's problem if you're afraid you're going to slip, which you can't seem to stop doing. And be careful about how you use your words, the way you were able to do that in your written filings. He was really about as excited as we've ever seen him. I wonder what it would take to piss him off, and I guess I wonder if we're going to see that at some point. This is a very restrained kind of trial and presentation and stuff and so far. And this is, we're in LDS country. These are very polite people. Very nice, polite people. Don't necessarily expect a whole lot of aggression or anything like that. But it's going to reach a point that you're throwing hands. I mean, it's a trial, it's contested, and there's witnesses that you don't like, and there's witnesses that are saying things that you think are ridiculous, and it gets combative. There are strong disagreements about all kinds of things that come up. And so I just, I'm just waiting to see. Is this judge like the zenest judge I've ever seen on the bench? Just very calm, reasonable, going to take our time, going to give you the benefit of the doubt. You haven't met your burden, but we'll let you go ahead and have your evidentiary hearing. And here we are staying late at court today. No hint of impatience or anything like that at all. Just everything's cool, just going with the flow. How terrible a witness is Jeff Gray? Isn't it funny how bad of witnesses lawyers are? They're terrible. Like we do nothing but tell people how to testify, and it's just the basic rules. Listen to the question, answer no more than the question that you're asked. Don't volunteer anything. Wait for them to follow up. Ask for clarification if you don't understand. If you don't know, you don't know. And he can't do any of that. Like, not a single thing. He just volunteers all this stuff, and he gives an answer, and then he's like, well, but I don't know, and changes it. This is going to read very badly. I don't think, as we're watching this, it doesn't sound bad. I think it sounds fine. It sounds like he's held his own. He's perfectly reasonable. But the record that this is going to be on a transcript is going to be messy, because it's going to be kind of full of contradictions. And the defense lawyer isn't, which I appreciate, because frankly, this is taking enough time already on something that is not going really anywhere. This is not going anywhere. But he's not resolving those contradictions. So it's just kind of there. From a technique standpoint, in terms of making the record, not really impressed with what I'm seeing so far. There's not a lot of pinning down of this witness, not a lot of clarifying inconsistencies. Yeah, I don't know that this is really a very good use of anybody's time, because this hasn't added anything material to what they already know about the relationship and the implications of it. This is all already, in the pleadings. And there hasn't been anything elicited that changes that in any significant way at all. I mean, I know that we're fishing here. And so the hope is, if I ask him if he had a conversation with Prosecutor A's wife, maybe he'll tell me that there was, but if there's not, then this is really a lot of waste of time. And so this is maybe why the elected doesn't really seem too bothered by this. He doesn't really seem too annoyed or too put out. And he could have, he could be seriously annoyed by being here on the bench, being asked his questions, having it implied, if not specifically accused, that there's something untoward happening here, that he's being misleading or he's been shady or whatever. He seems to me to be sitting there with the confidence of, there ain't nothing you're gonna find. So So go ahead and ask your questions. If there was something there, we would have disclosed it, but there's nothing here. And what there is what we disclosed. And we did that out of an abundance of caution, by the way, because we don't think there's any issue. And by the way, it was my job for 25 years to figure out if these kinds of things were issues. That's going to be a messy part of the record, because what he clearly seemed to be saying was that attorneys for 25 years, my job in the AG's office in the criminal appeals division was for attorneys to come to me to consult on questions. And that is pretty common when you have an appellate body or an appellate, attorney in your office or whatever. Yeah, the trial lawyers consult with them all the time, because the trial lawyer is thinking ahead to appeal. And so what do I need to do? And how do I need to make this record? And what's the best way to handle this issue and things like that? So very common to confer about things like that. But just the way it came out, it sounded like he spent 25 years handling ethical inquiries, and I think he clarified that. But it's just going to be this other part in the transcript where it's not really clear, and I'm not super sure that the defense attorney really hammered down what exactly he was saying his role at the AG's office was, and how that relates to his ability to make an informed decision about whether there is a conflict here or not, and whether he's able to do that without having to confer with anybody on the outside. What else came up? Somebody was having a hard time with it. Somebody from the ward. The ward entered the trial. This is going to happen inevitably. Guys, we're in Utah. The LDS is going to come into this. There's going to be a lot of LDS people involved. If that is something you're not real familiar with in the American West, like all over the whole West, we LDS is everywhere. This is not like really a, strange thing. So it doesn't surprise me at all that that's coming up. It might be new for some people to learn a little bit about it, I guess. I don't expect that anything about the LDS church is gonna feature in the trial, but it might, because it might relate to Tyler Robinson's background and what his kind of environment and beliefs and stuff like that were foundationally, and then the question is going to be, did that evolve, and if so, how and why and stuff like that. So I'm just going through my notes. Is there anything here? Anything here we didn't really know, didn't really have to deal with? We already knew there wasn't a firewall, and so then we had a whole bunch of questions about why, what's a conflict and what we think a conflict is and how we handle conflicts and different types of conflicts. And I don't know that any of that was helpful, because the bottom line is they didn't screen him. And so if it was a situation where the judge decides he needed to be screened, that's all that really matters. So maybe focus on that predicate, that establishing that there's a situation here that really needs to be screened. He did talk about how potentially a contested issue that, whether the shooter was on the rooftop. This is presumably one of the avenues the defense is going to be looking at, is the theory of how the shooting took place. So we kind of know that already, that there's going to be pretty much all issues relating to how the prosecution is alleging the crime took place. Those are at least theoretically contested by the defense. They're not going to roll over and say yeah, all of those things are absolutely true. They're going to be probing the details and the state's ability to prove all of those. Pretty back.
Consensus among council and Mr. Gray, we discussed this with the court staff who didn't object, that since it's 5:20 on a Friday, we should recess now and reconvene on February 3rd. As previously scheduled, we have a hearing that day, if that works for the court. So that's what we think we should do.
All right. And so that was a consensus I was leaning toward. However, I think it may be appropriate to finish out this testimony.
Yeah, finish with
Be
Gray.
Done with that. That way, when we start up, we're starting with a new witness. It's a little bit awkward to break, especially over this space of time, because he won't be able to talk. He'll be on the stand, and he can't talk to anybody about his potential testimony because he's under oath and he's still technically on the stand until February 3rd, and that could create complications given the nature of his profession in the office.
I assume that the state has some questions for their
Yes.
witness, and then I would.
Oh, I see.
We're probably an hour and a half
Okay.
adding everything
No,
up. from now.
you know what? You're right. All right. All right. Well, that makes sense. And to all parties, that's the consensus, the stipulation
Yes.
to the state. All right. Thank you.
And Mr. Gray did tell us that he has a flight later this evening, and just for total transparency, Mr. Burt and I have a flight to California, which boards in 2 hours from Salt Lake. So,
Your Honor, obviously, we're not asking that he not be allowed to communicate with the county attorney's office. If they
Sure.
just don't discuss his testimony, that'll be sufficient as officers of the court.
I appreciate that guidance. I just want to make that clear. It is a little bit tricky when somebody's on the stand and they come off the
Understood.
stand. All right. Well, I believe we do have a hearing set for February 3rd at 1:00. Does that comport with everyone's notes?
yes.
And we'll go ahead and reconvene at that time and continue this hearing, and we can take it from there. Does any party wish the benefit of the record?
I don't think we need to ask the court to order the witnesses to return or serve new subpoenas.
Yeah, no, I think the witnesses are planning on attending that hearing as well. We'll make sure that's.
We don't need the record for that.
All right.
If we are told we need a new subpoena for any reason, we'll do it.
All right.
Thank you, Your Honor.
Thank you, counsel. I appreciate your hard work today. I wish you a good afternoon and a weekend, as well as to Mr. Robinson. Court is in recess.
All right.
Oh, well, small blessings, I suppose. Look who came to say hi. Jude came in. I heard him chirp behind me. He's a very chirpy little boy. So, gonna do more of this on February 3rd. How exciting. How exciting. Who can't wait? Because everyone has flights, you see. It's Friday and everyone's trying to get out of town. And is this the long weekend? Is this the long weekend? Is Monday a holiday? I feel like it might be. So yeah, nobody wanted to take up my offer to let's just have a little late night. Let's just stick around till midnight with some popcorn and get our pajamas on and all that type of thing. So yeah, all I was saying before they came back to do that was just kind of, they were talking about the contested issues, the aggravator. They were concerned about whether she was in the line of fire because they're relying on the aggravator that the shot that killed Charlie Kirk placed others in grave danger. And so their theory is that basically anybody in the line of fire was placed in grave danger by that shot. It's going to be a jury question to decide. I mean, it's a theory that I think will get them, over any kind of potential legal challenge to the death penalty. But I'm just not sure how strong that one is going to be, just because of the angles, and it's a long rifle, and I don't know. We'll see. I think it seems to me like there's a much greater risk for anybody that's like standing behind him, because bullets can pass through people and stuff. And so that's always an issue is your backdrop. You know, if a firearm is shot, you need to know what's behind your target because you could be endangering that. But as far as like everybody who's just kind of in the line and in front of him, I don't know. He's going to have to convince the jury. We know it wasn't McBride who's involved in all of this because McBride is the one who helped student child A, whatever on earth we're calling this person now, prepare the affidavit for court. So wasn't him. McBride is not prosecutor A. Well, now they're going to have a little bit of time to reassess, reevaluate, think about how well what they've been doing so far has been working, and whether maybe they need to be changing their strategy. You know, maybe it's time to get a good spinner on that rod there if you're going to try to catch yourself a nice steelhead. But all in all, that was frankly kind of a painful day, and but for that nice little celebration moment we had of getting to celebrate the judge standing up for us. So we learned the defense told us today that they had filed their motion to ban the cameras from the courtroom. So I will be looking to see if that is available. There was another filing fairly recently. There's been this issue. I'm gonna get onto my Substack real quick here, just because that's the easiest place for me to find the the court docket at this point. So let me go ahead and pull that up. There was, let's see. Yeah, there was all this private stuff that was filed. So there was a private motion that was filed by the defense on January 9th, and it's got exhibits, and it's really unclear what this is. It's not specified. And so we know from the previous hearings that the defense has anticipated they were going to file to ban the cameras, and they were going to file to expand the gag order. Those were the two things that they said they initially wanted to file to have ready for this hearing on February the 3rd. They are way behind schedule. All of these things were originally supposed to be filed before Thanksgiving. Here it is, 2 weeks, a little more than 2 weeks before February 3rd, and they are just now getting around to filing to ban the cameras. And we still haven't seen anything at all about the gag order, which I have been waiting for quite patiently. It's possible they may have, I don't know, seen the light of calling into question whether it's really a legally meritorious position to argue that I've been kind of flippantly being like, Pam Bondi, you're going to try to gag Pam Bondi. I don't know if they're actually targeting Pam Bondi, but I know they've said federal investigators. And I know Pam Bondi has said things that they don't like and that they've taken issue with in the past. I know that the governor of Utah has said things in the past that they didn't like and that they took issue with. So there are, of course, some problems, legally speaking, if they intend to try to gag Pam Bondi that are probably insurmountable in my opinion, but I don't know. Let's go ahead and make that bigger so you don't have to squint. Anyway, this is the private stuff that just got filed. So seems like it's not the ban the cameras. Could be the gag. I don't know. It could be the gag, but they're not telling us. It's just some private motion that they filed. And so the reason why this caught my attention is because today, well, it came up yesterday, but I got it today, was this motion filed to the news media opposing this motion being private. So this is going to be something to look at. We've had a long day today. I'm not going to look at it right now. Maybe I'll just do a video at some point and go through that so we can kind of get up to speed. And then I'll also be going to check on their new motion that they said they filed today vis-a-vis the banning the cameras and see what that's all about. So plenty of things happening in this case, although they're all kind of collateral around the key issue here, aren't they? They don't really have anything to do with the substance of the case at all. They're all process related. Who gets to talk, who doesn't get to talk, how much we get to see, how much we don't get to see, who's doing the prosecuting and who's not. I think to close, you know, we were looking at the rule, and there's a whole bunch of commentary to this rule, and it would be a lot to go through. And like I said, we've all kind of had a long day, so I don't think I'm going to spend a lot of time on that. But I do think it would be helpful to just kind of briefly touch on what a conflict of interest is in this situation, because I've gone through and sometimes, like I like to star comments sometimes that I see coming up that's like raise good questions. You know, I try to catch stuff as much as I can. You know, I'm not just interested in what people have to say if they super chat me, which by the way, please don't super chat me today. Send it over to the fundraiser. Send it to Danny and Malyia so they can get over to Kansas City for Silver Glove National Championships. I have a hard time doing that, you know, watching the chat, like while I'm reading and while I'm talking and, you know, stuff like that. But a lot of times when court's on, it's easier to follow. And so I try to star things that come up. So I saw a lot of questions like this. Don't prosecutors represent victims of crimes in some capacity? No, they absolutely do not. They do not represent victims of crimes, other than just in the sense that the prosecutor represents everybody. The prosecutor represents everybody. They represent the state, and they represent the state as the aggregate of all of us. And so not any one of us individually at all. They represent the defendant just as much as they represent the victim. And so that's part of what kind of puts them in this special position as a prosecutor, to not be just a mere advocate for somebody. They represent all of us. And so they're supposed to represent like the overall justice of the process. And that's why there's, you know, lots of famous court decisions and, you know, language from rulings. And there was like famous speeches and things like that, very specifically about this obligation that prosecutors have, not to just win cases, but to do justice. So they don't represent any one person. And that's what makes determining what's a conflict of interest for a prosecutor different than recognizing what's a conflict of interest for a defense attorney. Because a defense attorney, I can point very specifically to who my client is, you know? And so is there something that interferes with that? If that client had, I don't know, dated my sister and ghosted her, might I have some hard feelings about that defendant? I might, you know, and so you're able to figure that out real clearly, kind of how those dynamics work. With a prosecutor, it's a lot more different because their duty is to this broad concept of doing justice, and so that's really what you have to show is being undermined by whatever the conflict is. When I was in law school and we were learning about conflicts of interest, the teacher gave us the example of go ahead and sit yourself in the courtroom and look around and see how many people are present. And if the answer is more than one, there is a potential conflict. And this is kind of a flip way of putting it, but it's true because people always exist in these relational kind of networks. And people are connected to people, and you know, people have their own viewpoints and their own biases and values and things like that inform how they see the world, how they see and judge other people and think about them and so forth. But anytime you have more than one person involved in a case, you have a potential conflict because you have potential relationships with all these people. And so the fact that there are relationships between people is not in and of itself what means somebody has to get out, because that's always going to be the case. the public defender works in the court with the same prosecutor over and over and over again. That doesn't mean they have a relationship. They have a working relationship. They probably even have opinions about each other. I like this one. I don't like that one. It doesn't mean that there's a conflict of interest because they have that history together. It has to meet that threshold of either because of the type of relationship it is or because of some kind of distinct impact it has on you. It's going to limit your ability to do your job. And so where that might change would be like, if I become a victim of a crime and some specific prosecutor prosecutes that on my behalf and I'm a witness for them, I'm their victim and so forth, you have a different relationship there. Could that change the situation to where maybe I shouldn't be defending cases that prosecutor is prosecuting? Yeah, it probably would. It probably would. But just, I've worked with this prosecutor a lot and I like him. That's to be expected. And it's the same thing with the judge. The judge sees the same people in front of him all the time. The judge has opinions about the people that appear in front of him. Having an opinion about something, by the way, is not what bias is. I think this is a really important point, because ultimately conflicts are about, you have a bias. But a bias is not the same thing as having an opinion about something or having an impression about something. That's just a product of having information. When you get information about something, you're able to form judgments about it. So I deal with somebody one time and there's a pattern of conduct and I form an opinion about it. I like it. I don't like it. I would like to repeat it. I would not like to repeat it, whatever. That's just a normal thing. You have an opinion about it. That doesn't mean you're biased. What means you're biased is when you can't change that opinion, when there's some reason why that opinion is so fixed that you aren't going to be able to shed it. And it's going to color you. Instead of like new information allowing you to develop your opinion, it's going to prevent you from accepting that new information. You're going to reject it because you're fixed in your opinion. And so you're going to do the cognitive dissonance thing and all of that. That's what you're dealing with specifically in the conflict of interest situation. And so that's why there's presumptions that certain kind of relationships are always going to put you in that position. A family relationship, it's just presumed it's always going to put you in that position because those bonds are so strong. The knowledge is so deep. With a financial relationship, your interest is so always there, so personal, so tied. It's just presumed that that's going to affect the way that you see things and your ability to incorporate the possibility of a reality that isn't in your own interest. It doesn't fit your notion of how you want things to be. So that was a really good question. I wanted to bring that one up. This one I saw too. The thing is, everyone wants to stay on the case. It's a political prize. I think there's some truth to this. I mean, of course, this is a high-profile prosecution, but I think it's also more than that. I really do, because I talk shit about prosecutors a fair amount. I'm not deluded about that or anything, but prosecutors are like cops, the good ones you need and you want and you value good ones. You got to have good ones. And there are good ones out there. It's the bad ones that everybody like universally doesn't like. And so good prosecutors, they have a real strong sense of responsibility to their community. They were elected. This was the job and the responsibility that they took on, and they take that very seriously. And so I don't want to discount that, at least the possibility that kind of thing is at play, because I don't know these people. They seem like pretty decent prosecutors to me so far. But I don't know, we're just getting this fairly limited view from what's been filed so far and how we see them behave in court. From how I've seen them behave in court, I'm like, I'd love to have these guys as adversaries. They look like they're super easy to work with. They look like they're not the kind of lawyers that you go to court and you spend the whole time, in like a hypertensive state because you're just so aggravated all the time. It's not that kind of scene. That's not the impression I get. But obviously, that's just a kind of superficial read from a fairly limited selection of observations. So yes, it is a political prize. There's no question about that. This is a big deal. It's, has the potential to be a big feather in somebody's cap. It's going to be on resumes in advanced careers, and people are going to give interviews and all of that type of thing. Maybe write books, maybe we'll get a Bugliosi out of this. Someone will write a book. But I don't want to undermine the fact as well that, part of the reason why prosecutors want to stay on the case is because they take that responsibility to their community seriously. Good ones do. And the crime happened there. It affected their people, their constituents, and they feel a duty to be the ones that are taking care of that. Even if you've consulted on conflict issues, it doesn't necessarily mean he can decide well on his own possible conflict issues. It's like how surgeons don't operate on their loved ones. This I thought was a good comment because, yes, I mean, this is kind of getting into the heart of what makes a conflict and what makes it problematic, because when you look at this context, the surgeon operating on their loved one. Now, first off, you can correct me if I'm wrong. My understanding is there's not a hard and fast rule that says you can't do that. It's just that it would be so strongly discouraged, and everybody kind of understands implicitly you would try to avoid it. But if something happened right there and it's an emergency and there's no other option except you providing medical care for your loved one, are you going to be in ethical trouble if you do it? I don't think so. So there's always gray area with these issues. But part of the reason why this is an issue is because you have to look at the significance of what's at stake, because surgery is potentially life-altering and life-threatening. And it can affect your judgment. I would put you as like a counterexample in a courtroom. Can a parent represent their child? Can a parent represent their child? And the answer is yes, they can. It might not be a great idea. There might be a lot of reasons why you would maybe choose not to do that. But people do represent their relatives all the time. And that's more in the line of like a waivable conflict in the law. Like you would disclose, hey, you're my sibling. That might interfere with my ability to objectively evaluate the evidence against you. It might interfere with my ability to make recommendations that I think you don't want to hear. Might affect my judgment. You might be better off getting another lawyer. And so having considered all that, you can waive it and have me anyway. It's not going to be against the law for somebody to do that. It just might not be the wisest course of action. So it would be so much easier, I think, if a lot of these things were black and white, but they just aren't. And it's because it's about those relationships, and there's so many, possible universes of relationships that can come up. Just so many different manifestations and dynamics and stuff like that, it's very difficult to make a hard and fast rule. And especially one that is kind of following this middle path where you can't just say any relationship means you're out, because then I've worked with this prosecutor a bunch of times and I kind of like him. That means I'm out. You can't do that. You wouldn't be able to have an operational, like a functional legal system under a rule like that. So it has to be more stringent than just there's some kind of relationship that I have personal feelings or judgments about. And it gets tricky, kind of working around the edges with that. All of that said, this issue so far, not seeing it as a close call for me. I'm really not seeing it as a close call. If this child was a material witness, if this child had seen something super important, had seen the gunman running across the roof, and I mean, anything like that, had seen preparatory steps, then yeah, we're going to be maybe in a little bit of a different situation. Because you're getting into a situation where the prosecutor has to be able to consider the possibility that this witness is wrong, that this witness is fabricating, and how are you going to handle that? How are you equipped to deal with that? Are you equipped to deal with that? And when it's your own child, that could potentially be a problem. But everything that we know so far, and nothing that has come out since, suggests that this child is different from any of the other 2,999 people who could be called to testify to pretty much exactly the same thing. There's just nothing unique or necessary about this experience. And the having feelings about it, even if the prosecutor had feelings about it, that's not enough. That's not enough. Are those feelings so fixed that they can't be influenced by additional information? And I'm not seeing anything here that really suggests that that's likely to be the case. So I love you guys in the chat. I really appreciate all your comments so much, and wanted to take the chance to call some of those out so we could chat about them a little bit. A couple of you guys who super chatted me, even though I asked you not to. Bass player 211 IFY. Don't film my defendant. He might look bad. Rittenhouse, anyone? Did the media treat him fairly? You're going to have to ask Jeff on this one. I really missed a lot of the Rittenhouse trial. This was back when I was still very, very deeply in the trenches in public defense work. So my schedule was very feast or famine. Sometimes you have time to watch trials. Other times you're just slammed with a whole bunch of work to do and stuff. And Rittenhouse did not land at a good time for me. So I didn't get to watch a whole lot of it. But Jeff watched a fair amount of the Rittenhouse trial. And so he would be the one to ask about whether the media treated him fairly or not. I would suspect they probably didn't, just because in general, most of the time, I don't think criminal defendants get treated all that fairly, unless it's somebody that for whatever reason, they really, really want that person to be acquitted. They really want that person to get off. Then they'll be really, really super, super fair, super generous. But I think most of the time they don't. They kind of glory in the lynch aspect, of dragging this guy out in public and having our public shaming and all that type of thing. It's kind of glorified. T-Rex Travels. Did the judge make a mistake not asking the AG's office to do an independent investigation and write a briefing on the potential conflict of interest? No, I don't think he did at all. I think at the end of the day, what the judge is saying is that the likelihood here is very strong that this entire motion is going to be denied anyway, because what the defense has brought doesn't meet the threshold of establishing that anybody's got an improper relationship with the case, or that there's anything here that is going to influence the prosecutor in a way that is impermissibly inconsistent with his duties to do justice for the public. I mean, so far we haven't even seen anything that suggests there would be any conflict with, even if his daughter was a witness. Right? There's nothing here that suggests the daughter has exculpatory information that would be helpful to Tyler Robinson. And so even if everything that we take is true, the witness's observations are consistent with the prosecution theory. So their interests are in alignment. There's nothing here that is really a big gotcha as far as the motion goes. So I think the judge is kind of already seeing down the road that this is extremely likely where we're going to end up. We're going to go ahead and have this evidentiary hearing anyway, just on the off chance that there is something that hasn't already been brought up, some smoking gun that's going to change the situation. But he doesn't expect this this lawyer to, you know, land the white whale with his little worm on the hook here. It's possible, but he's not expecting it. He's expecting this is going to be a long day with no bites and you know, just not ultimately productive in terms of generating evidence that would give him a reason to kick the prosecutors off the case. And so given that, no, he's not going to waste time and just go through this unnecessary process of bringing in an outside body. It's just there's nothing that has been pointed out by the defense that suggests this is legally required, that he's making a serious mistake if he doesn't do this on the basis of the showing that they've presented. So that's kind of where I think this is ultimately going, and why the AG being involved is really not necessary. Now, let's say the facts were a little different. Let's say the daughter did see the shooter running across the roof, you know, did see something that might make her more material as a witness. Or she, I don't know, passed Tyler in the stairway, you know, saw this guy limping up the stairs while she was going over to the amphitheater, and he was going up, and she thought, oh, that's weird, you know, this limping guy, something like that. Passed him, overheard him on the phone in the walkway. I mean, something material, then that might change it, because now you've at least made a threshold showing that at the very least there's a risk this person is going to have material information in the case, and so is going to be a participant in the case. It doesn't necessarily give you over that next hurdle of so is there then a significant risk that the prosecutor's ability to do justice, you know, represent the people and the people's interests is going to be materially limited by that. But there's at least kind of more of a possibility, because there's just more ways that can go sideways. So in that situation, would the judge have maybe been a little more receptive to this idea of bringing in the AG to evaluate things independently? Maybe. Or even some other possibility. You know, they had mentioned, the defense attorney had mentioned in his cross-examination, well, it's not even a cross. He's conducting it like a cross of Mr. Gray, but it's really a direct, but they're letting him get away with treating it like it's a cross. But he had suggested that you could call the Utah State Bar Association and get guidance on your ethical issues. He could potentially just do something like that, you know, refer it to the bar, get an opinion from them on whether there's a disqualifying conflict here or not. But it's just because those aren't the facts. Because I think that's really the key issue here, is that the witness didn't see anything important. The witness is not unique relative to what, I mean, and it's not, frankly, different from what everybody who was on the internet on September the 10th saw the video come through, whether they wanted to see it or not. You know, it was everywhere. We all saw essentially what this witness saw. And so there's nothing unique. There's no particular value about that changes the situation. So, what a day. What a day. It was like real roller coaster. I feel like I had that whole like adrenaline buildup with we are going to have cameras after all. And then just this letdown into the boring doldrums of what the hearing actually was, which is, I mean, that's court in a nutshell, right? It's not going to be exciting and dramatic every moment. There's plenty of dull moments, as all of you trial watchers know. But just a little like, I don't know, up and down roller coaster. Now we're in that, at least we didn't go till midnight, right? At least we didn't have to go till midnight. Well, guys, we'll definitely be back on February 3rd to pick up more of this this incredibly riveting time. But it is important stuff, I think, to see what's going on, and it's not entirely possible that they're going to land the white whale. But we'll see if they develop anything new. We'll be back for that. So want to thank you all again, those of you that supported the fundraiser for Danny and Malyia. We are, guys, let me share this because we are getting closer and closer. We are up to, let's see here, $1,991 is raised. We are almost 2/3 of the way to the goal, guys. Really appreciate you so much. Can't tell you how much these kids deserve it. Really an awesome thing for them and a great opportunity. So thank you all so much for that. This has been a little bit of a crazy week. This week went super sideways for me from the outset. I got super sick out of nowhere at the beginning of the week, and so completely lost a whole day. And then the next day, the day 2 is always like you're recovering from the bad day. So that was just like a total wash. And then we had, of course, the cats. Both of the boy cats had their procedures done, and so there's been kind of some monitoring and some babying and some comforting and stuff like that needs to happen. So just paying attention to the cats. But I've been trying to watch the Uvalde trial. I'm planning to put some recap videos out about that. I didn't want to watch it live because it's awful. I mean, bottom line is it's awful. It is awful. It is horrifying in so many ways. And so I didn't necessarily want to spread all that around, particularly for anybody who didn't want necessarily to be exposed to a case like that. Very normal, insane thing to keep your distance from that type of thing. But I also kind of wanted to have the opportunity to if this I can't handle this, I don't want to listen to it to be able to back out. But I have been listening to it so far, and I definitely have just a lot of thoughts about it. So I'm planning to do some recaps of that. I'm probably just going to do them week by week, honestly, because at this point it seems like it's going to go on forever. And there's not really a whole lot new, in any kind of big and meaningful way that's happening on a day-to-day basis. It's just every day it's kind of a little bit the same and a little bit different. But I mean, I guess I'll just give you the bottom line. None of it to me is really getting them to where they need to be from a prosecution standpoint. So I am planning on putting some stuff out about that. There's been some other stuff going on, huh? I've got some notes somewhere about the things I want to talk about. Oh, we've got Brian Koberger, that civil suit that was filed against WSU. I have some things to say about that. A lot of people have looked at this, the civil lawsuit that the survivors of the family filed against WSU, and mostly focusing on the factual allegations and things like that. It makes several allegations, basically that Koberger was, sort of a problem from the start. As soon as he got on campus, people complained about him and kind of how he interacted with them, and thought he was super creepy and he didn't take cues well and things like that. And that at some point the allegation is he then started to stalk the girls in the house in Idaho, ultimately culminating in the murder. So it's trying to kind of hold WSU responsible for not doing something before about Brian Koberger. I don't really want to focus a whole lot on the factual issues because one, they are allegations, and two, a lot of it is either kind of stuff we already know, either because it came out when reports and things like that started being unsealed and released after he pled guilty and was sentenced. We got police reports about interviews of the folks at WSU and these sort of complaints about, he would talk to me and not leave and things like that. That I don't know, people, you have different opinions about that. To me, it was like none of this is really inconsistent with somebody being autistic, not necessarily picking up on you sending signals that like, I want to go home, and you're not asserting yourself and saying, hey, I'm going home now, we'll talk later, or something like that. And then some of it is just repeating allegations that have already been debunked. Like we have the prosecutor specifically saying on the record in court that the girls in Idaho were not stalked. They have no proof that Bryan Kohberger ever stalked the individuals that were murdered. So I don't want to focus on the facts because it is, like I said, just allegation, and there's not really anything in it that is new. It's just kind of, frankly, dramatized version of what's kind of already been out there and already been alleged. And may or may not be accurate anyway. But there is some law in Washington that is going to apply to this particular case. It is filed in Skagit County, Washington, which was an interesting choice. But and because of that, I have some thoughts about the viability of this lawsuit and the likelihood of it getting very far in the litigation process. So I do plan to put something out about that. I've got something coming out in the next couple days about the Robert Devine has appealed. He's appealed to the Superior Court. He's doing it pro se, and it is just an absolute train wreck. So there is so much to mock with old Robert Devine's appeal. We'll be looking at that. Some other things I'm kind of interested in. So in Nicolas Maduro's case, there was this weird little incident where this attorney files a notice of appearance, but he's already got an attorney, and the attorney he has moves to strike this other guy's notice of appearance because he's like, he doesn't belong here. The guy's never even met him. So that was kind of strange, kind of dramatic. I have some thoughts about that. So I thought I might film something about that as well. And then just, stuff kind of seems to keep happening, doesn't it? We got the Timothy Busfield thing that just came up in New Mexico, the charges against him. That's going to be fairly high profile. We're still waiting for news on what's going to happen with Mickey Steins and his allegation of the conflict of interest. He says the judge has a conflict because some relationship with the murdered Judge Mullins at a conference that took place just the week before. They're being a little bit vague on the details, but haven't got a response to that yet. Not really sure how that's going to flesh out. So much going on, a lot to keep up with. And of course, exactly like the wrong week for getting sick and having the cats have surgery and all that type of thing. But hey, it is what it is. I've never laid claim to be, the first one to really have anything to say about anything. I'm not the newsbreaker. Sometimes things have to simmer a little bit anyway. So that's just some stuff to look forward to. Some of it here, continue to put out stuff on Substack. If you're watching on Substack, one of the things I did recently is I picked up the documents from Candace Owens's case, the Macron's defamation lawsuit against Candace Owens. So I've got some of those posted over on Substack as well for you to pay attention to if you are so inclined. You can read them for yourselves. I've got the complaint, and then there's a motion to dismiss. That's where the status of the case is currently. All of the documents relating to that have been filed and are available. So we are waiting for a hearing and a decision on that. Maybe not a hearing, I don't know, but at least a decision. So that's going on over on Substack. And of course, continuing to watch Christy Martin, the trial of Jim Martin. all kinds of things, all this stuff, not enough time. That's life, isn't it? But at least it's winter. And so not necessarily being torn away with like the driving desire to, I don't know, spend time outside and stuff like that. Although it hasn't been a bad winter here. I don't know where you guys have been. We've actually had a super mild winter. It's crazy. It's like we normally get to like 0, maybe a little bit below 0, but 0, get some snow, stuff like that. We've like barely hit 25 maybe this year. It's been extremely warm, kind of damp. Can't really complain too much, but nevertheless, it's just, the days are short and all that. It's a great time to sit inside and watch cases and talk about them and stuff. So those are the things to look forward to here, guys. Don't know if I'll be doing a live again before February the 3rd, but if I do, you know how to get the notifications and stuff. I'm not gonna tell you how to use YouTube. Use it however you want. If I go live, I'll go live. And if you got notifications, you'll know. I usually put stuff like that out on X too. So appreciate all you guys joining me today and hanging out for what was a little bit of a all over the place kind of hearing. A real exciting and then real super doldrums, but that's just how it goes sometimes. So with that, I want to thank all of you, especially the mods. Thank you, you wrenches coming through. Really appreciate your contributions to the chat, to keeping it an awesome place. Sharing that link to the fundraiser, really appreciate that. And just all of you with your awesome questions, contributions. Everybody's, I like, this is a case where people have lots of different opinions, and we like that. Like, I think that's a great thing. I like when people have different ideas, and people have ideas that are different from mine. It's not something that I take personally. You disagree with me, like who am I? I'm just a person with an opinion too. So I like when we get to air those in a respectful and just with an attitude of curiosity and bettering ourselves and exposing ourselves to new perspectives and things like that. It just, I don't know, I think makes us all more wise people to do what we can to see things from others' perspectives, so that we can kind of evaluate where we're coming from ourselves. So thank all of you for making that possible. And yeah, get some rest tonight. I'm going to get some rest tonight. About not quite 6 hours today, but it was a long day, and it was a little chaotic. So might need a little bit of recovery from it, but that's fine because now it's the weekends and we got all that time. Just because it's dark out doesn't mean you shouldn't take care of yourself. Doesn't mean you shouldn't get that little bit of vitamin D when you can. So if you get a chance this weekend, hey, do what you need to do to look after yourself. Winter can be tough. Winter is a little bit of a it's like my tougher time. I find it very easy to be, energized and motivated and stuff like that, optimistic in the summer. It feels like the days are going to last forever. They just go on and on and on. And winter is really not like that at all. It just feels like you barely woken up and like you're already kind of getting ready for the day to end. So maybe you're like that too. If you are, hang in there, because the days are already getting longer. It's like a minute and a half longer every single day at this point. So by the time we go live again in about 2 weeks, if not sooner, the day's going to be like 15 minutes longer. It's going to be awesome. So all you got to do is just wait. That's the beauty of time, is that you don't like how things are right now. Just sit yourself down, be a little patient, and guaranteed it'll be different. So with that, guys, thank you all once again. Really appreciate you all so much. Glad you have the interest in this case and in the legal system in general. It's my honor to just participate in trying to shed some light on it from my perspective and experience. I'm glad that you all appreciate it. And we will see you all soon. Thank you so much.